Good morning. Thank you all for coming. Welcome to our meeting about the regulation of food environment in Brazil. This is the Law School of the University of São Paulo. My name is Diogo Coutinho. I'm from the Department of Tax and Economic Law. It's a pleasure to have you here with us. This is a partnership we're proud of. This is a partnership between the Global Center for Legal Innovation on Food Environments. We have the O'Neill Institute for National Law from the Georgetown Law School and the Group for Public Policies here at the São Francisco School of Law from the University of São Paulo. We want to understand the role of law with public policies and its connection with public policies. The role of this group is to create knowledge in order to turn public policies into more effective and democratic public policies. I would like to thank Isabel Barbosa and Oscar Cabrera, and I would like to thank for this fruitful collaboration we've had throughout the last 2 years, Isabel. When the O'Neill Institute uh, began supporting our studies and our research. Today's discussions are timely because perfecting regulatory arrangements of food systems in Brazil is very important because food is key for the population's well-being, and also because of this institutional construction that faces huge challenges, and it was dismantled by an ultra-liberal government and authoritarian administration when it comes to public policies, and an administration that's highly incompetent when it comes to operational and technical abilities. We will have a presentation with Ana Paula Bortoleto, the keynote speaker from the University of São Paulo. Thank you very much, Ana Paula. I know that you have a busy schedule. And we will also have 3 panels that will talk about multidisciplinary and complex problems, just like the food environments we're going to discuss today. All panels for this event are about the challenge of regulating, in the best possible sense of this term, public policies and markets in order to correct possible flaws, but also to shape these environments for the benefit of consumers and citizens of all ages. We believe that well-structured regulation and competent regulation is beneficial not just for companies, but most of all for people. Although not all companies believe in the regulatory efforts that a country such as Brazil is conducting. In our first panel, we're going to talk about the role of advertisement and marketing for food products. What regulatory measures can discipline these practices in order to ensure transparency, information, and freedom of choice? What are the legal resistances we face? What are the main controversies brought about by advertisement and marketing? And how can we face these challenges? The goal is to discuss regulation between 2 extremes of full prohibition and full lenience on the other edge of the spectrum. In the afternoon, we're going to break for lunch. And then in the afternoon, in our first panel, let me just speak about our breaks. We're going to have a coffee break and we're going to have lunch in a restaurant we will refer you to. And at the end of today, we're going to have a happy hour in the Visconde de São Leopoldo room, which is right beside this room. And we hope to have a moment, for networking. And we want to celebrate the publishing of a volume of our Institutional Studies magazine with texts about the topics that we will discuss today. Well, in any case, in our second panel, we're going to talk about the positive and negative externalities brought about regulation or the lack of it in the field of food and nutrition. What is the impact of this in courts in terms of compensation or damage suits, and what we can discuss and what can be said about litigation caused by legislation and its impacts in the Brazilian judiciary. How are courts dealing with these regulations? How do they analyze, and what are their decisions as judges about public policies for the food environment in Brazil? And what are the impacts of current claims? What are the precedents? And how can we try to build new regulation from now on? And in the third and last panel, we're going to discuss the interface between regulation and public policies. What do we have currently in terms of public policies, government actions that foster healthy food? What are the innovations we identify? What are the bottlenecks, the limitations, challenges we face from a legal or funding perspective or from a coordination perspective? What type of diagnosis can be done when we analyze factors that hinder or foster public policies? These are fascinating debates, and we have very special guests today, respected and renowned experts on the topics we're going to cover today. So both the O'Neill Institute with Isabel and myself representing the School of Law, we really want to thank all the experts for joining us. We are going to introduce these experts when the time of their panel comes, but I would like to thank everyone who's here for this event, whether you are here as a speaker or in the audience. We also have live stream, and we hope that you have the freedom to interact and dialogue as if you were here, as if this is a free horizontal arena that allows us to interact. This is going to be a very valuable day with so many interesting speakers. So once again, thank you all for being here. I salute everyone who's here. Welcome. And we want to have this on record. We hope this will bring about new possibilities for research, for engagement, for public interest. We want to keep on working together, the academia and civil society organizations, legal entities, people who represent different professions and interests, but people who are here on behalf of a common cause. So I now give the floor to Isabel Barbosa from the O'Neill Institute. Thank you, Diogo, and I echo your words. I'm going to try to be brief. First of all, I would like to thank you, Diogo, for the partnership, but all researchers from the Public Policies Group in the Law School of the University of São Paulo. This is the third year of our partnership, and it has been a huge pleasure. We learn a lot from you. Our meetings, our discussions, our joint efforts are very enriching. So this is my first thank you note. I'm here representing my colleague, Oscar. You probably know Oscar Cabrera. He really wanted to be here with you, but he had a family issue and he had to go back to Washington. But he's following us remotely. If you don't know the O'Neill Institute, this is a 15-year-old institute, and it's hosted at the Georgetown Law School. And it's right at the intersection between the academia and practical work. So real academic research to contribute to the joint solution of many problems we see in public health. And with a very similar approach as the Group for Public Policies, we are very much aligned, I believe. And about 3 years ago, the O'Neill Institute created the Global Center for Legal Innovation on Food Environments, which was already mentioned here by Professor Diogo Coutinho. This center comes from the understanding that public health cannot be separated from healthy food and diet. So the goal is to really understand how law can help to improve um, food systems, healthier food systems. And it has been a pleasure to meet many wonderful researchers and to work in partnership, in close partnership. So thank you all very much for being here. I'd like to thank everyone who's watching remotely as well. Um, Many people registered to be part of this, and we're available. We are very excited after so many years of, isolation. Being in person with you is really valuable, and we hope you all enjoy. So thank you very much. Thank you, Isabel. Well, that's what we wanted to say for our opening remarks. So let's have our first panel. Well, actually, it's not a panel. We're going to have a keynote presentation with Ana Paula Bortoleto. And Mateus Adami is going to be here with her. So now let's give them the floor for their presentation. Thank you very much. Good morning, everyone. My name is Mateus. I am a researcher at the Law and Public Policies Group, and I was part of a research with the O'Neill Institute, a research about regulation. It's a pleasure to be here introducing Ana Paula Bortoleto, our keynote speaker. Ana Paula is a researcher on sustainable and healthy food environments, and she is a researcher on nutrition and health at the University of São Paulo. She is a member of the nutrition practices community and of Informas, and also of the Abrasco regulation. She coordinated the IDEX regulation program. And our keynote is a little bit different. It's going to be a dialogue, actually, a conversation. And we're also going to have 15 minutes for a Q&A session after we finish. So my first question to Ana Paula is, what is the importance of regulating food systems? There are many norms and many different fronts. Can you talk a little bit about labeling, advertisement, and the use of the state's purchasing power to help lead to healthy public policies or public policies that lead to health and nutrition? What is your perspective on the importance of regulation of food uh, systems and environments? Thank you, Mateus, for your presentation. Thank you, Professor Diogo, for the invitation. It is a pleasure and an honor to be here with all these researchers to talk about food, environments. And it's important to have this conversation this morning. This is such a timely topic, and it's the topic of my research as well. So I'd like to thank the GDPP, or the Law and Public Policies Group. I'd like to thank the Global Center for Legal Innovation on Food Environments. So talking about the regulation of food environments is really a key. It allows us to talk about healthy food choices. We want them to be accessible, cheaper, and easier. And we want to also try to reduce the offer of unhealthy foods. Regulation creates this balance and tries to add value to healthy foods. This approach actually overcomes an outdated and traditional perspective in the nutrition field, looking at a more individual and prescriptive approach on how people should eat, always blaming unhealthy habits, blaming people for unhealthy habits. We know, however, that the food environment and the relationship between people and food is always fostering unhealthy eating habits. There is plenty of evidence and research that shows that just looking at an individual approach, or just talking about food education or how people should eat, is not enough to ensure healthy choices. All these initiatives that use individual approaches fail in having long-term impacts and a populational impact, because you ignore all the influences that lead to what people actually eat. So it's really important to think about regulatory approaches that are not just about an asymmetry of information, but also helping to place this into a collective environment. Looking at food environments, I think it's important to talk about Josué de Castro and his legacy. We have been studying his work in our school, and ever since 1946, he published the book Geography of Hunger. Josué de Castro had already talked about social determinants of food choices, and he talked about nutritional characteristics in our country. He took into account a historic and geographic context, also our culture. And at the time, he talked about an eating monotony. And now we are moving towards a different eating monotony, but it also is determining for inequality, for political choices that do not value healthy eating habits. Brazil is moving back into a situation of lack of food security. Some public policies were dismantled, public policies that were renowned abroad, even in this fight against hunger. We cannot ignore this. These are coexisting factors with political determinants that are connected to our eating habits as well. As a consequence, we have NDCs or NCDs. Brazil was once an example in the world for fighting hunger. But there's a lack of positive experiences when it comes to reducing NCDs, most of all obesity. Most of the paths connected to fighting hunger and structuring policies, emergency policies, we have already built this. There's just a need of political will and investments to change the scenario. There are still many gaps when it comes to public policies that ensure access to appropriate eating habits. So it's really clear the relevance of this debate. Well, speaking of NCDs, there's an exponential increase of NCDs such as diabetes, high blood pressure, not just in Brazil, but around the world. These are, I would say, one of the main challenges of the 21st century. No country in the world has been capable of stopping this increase in obesity levels. Individual strategies have failed. In 2021 alone, 45% of deaths in the Americas were caused by NCDs. Chronic diseases connected to unhealthy eating habits are responsible, or they cause very high impact in the population. They're not just negative from a health perspective. Data from 2019 shows that in just 1 year, 83 million years of lives were lost due to premature deaths or time lost in therapy, a time that people could have spent working or studying. So there are impacts in the economy, in social life, and in society in a broader way.
Well, besides those challenges, we have the impact of the COVID pandemic and also of climate change, which we won't have time to discuss today. But I think we must take into account the entire picture when we discuss the importance of regulating food environments. And this very complex scenarios was recently portrayed by a UNICEF study in which they analyze the eating habits of children of 6 years old that are 6 years old in Brazil and also in the semi-arid region. What was shown is that during the pandemic, 82% of the families interviewed said that children could not be fed during a meal because there wasn't any money to buy food. But at the same time, they also reported wide access to ultra processed food, a very vast quantity of ultra processed food. This points out to the need of building public policies that will address the impacts on high vulnerability families. So speaking of regulating food environments is also a matter of equity and protection for those more vulnerable families. So confronted with this challenging scenario, there are several possibilities and approaches. Systemic solutions for these problems must be found because tackling problems in isolation will add more problems to human health and also the environment. It's important to make recommendations, just as, for example, the food guides and other initiatives that will contribute to the information about the health groups that are not healthy, looking at food in a more comprehensive way. In 2009, a new classification was created in which industrial processing was described for the first time as an important way of understanding the relationship between health and food, especially the rise of ability. And this was a classification that was incorporated to the Brazilian Guide for the Brazilian Population to 2014 and is also being incorporated to other guides elsewhere in the world. So food is classified in 4 groups, depending on the type of processing. We have, for example, in natura or lightly processed foods, for example, either dry food or only packaged. Group 2 culinary ingredients such as oil, sugar, and salt. Group 3, with processed foods, in which in natura food is conserved through the addition of sugar and salt. And group 4, which is the one that causes great trouble, which is processed foods, with food formulated in an industrial manner, and that are not food by themselves because they are products and they contain substances that are not commonly used in cooking, in culinary preparations at home, and that in addition to those substances also contain additives and also colorants, dyes, and other ingredients that change the texture, and also, and of course, there's very little content in terms of real food. And it's important to note that usually this is food that is made by large corporations, and ultra processing is done with the intention of making those products highly profitable and very appealing to the audiences, and intrinsically unhealthy. They comprehend several steps in processing in which nutrients are removed, salt and minerals are eliminated, and salt and sugar is added. This creates a combination that is at the same time highly palatable for users, but very low nutrition content. You probably all heard about syrups and also modified starches, modified oils, hydrolyzed proteins, and milk whey protein, and also cosmetic additives such as dyers, emulsifiers, and also sweeteners. Understanding the characteristics of this group of foods and its negative impacts on health is something that's very well consolidated in the scientific world. There are several studies associating ultra-processed to health hazards, and the evidence that is produced is very solid, and they confirm the association between ultra-processed foods with diabetes, obesity, some types of cancer, and also premature mortality, among other issues. And it's important also to say that the mechanisms that create this impact on health are also being investigated, and the relationship goes beyond the nutrition composition. Ultra-processed foods, in addition to having negative nutritional characteristics, contain additives, and the way those additives are combined are also factors that can explain the negative impact on health. For example, high palatability and the appeal that is created is something that also drives excessive consumption. It reduces society, and this definitely goes beyond just the nutrition content. So when we talk about regulating food environments, it's important to see how we can restrict access to this group of foods. Under the new classification, there are some descriptions that try to outline this group of products, but for regulatory purposes, it's important to discuss what adaptations must be made. I think it's very important that we talk about this today, about how we can contribute to the definitions that we need to make. So Brazil is a pioneering country because we have a guide based on the new classification, but other public policies against poor eating habits and also NCDs are very important. The Josué de Castro unit published last year a document, and a lot more evidence has been produced since then, um, discussing the impact of ultra processed foods in the projection of deaths that reached 75,000 deaths in Brazil. So, in this document, we made some suggestions of public policies that could regulate food environments. For example, front of package warnings and labeling, regulation of advertising for children and adolescents in digital media, offer of and supply of ultra processed in schools, taxes on ultra processed foods and sweetened beverages. Today we have more evidence on that, but it's important to discuss how we can expand this initiative. I think that Colombia has made progress in that direction. And of course, I won't have time to give you all the details, but evidence shows how effective taxation is to discourage people from adopting poor eating habits and drinking sweetened drinks. WHO recommends an increase in price of 5% also to improve health outcomes. And the last proposal that we discussed, in addition to taxation, was to reduce the price and adopt strategies that will promote minimally processed foods. So nutrition and labeling. This is something that we have been discussing in several countries, and specifically front of package labeling of warnings is something that creates high impact. It's also a symbol because in the front of the package, you find information about the high content of harmful ingredients in that ultra processed food. And like that, the consumer can become aware of the risks she's running. This type of labeling helps identify very quickly the less or the more unhealthy foods, and also deters and dissuades consumers from making that purchase decision. The warnings can also discourage the makers of those ultra processed foods and lead them to reduce the amount of harmful ingredients. And this is even more beneficial because when you have a set of rules that is used for classifying foods and a set of warnings, they can be used. Otherwise, there is always a risk that the industry will meddle with the composition in the way that, for example, they remove some sugar but add some salt just to make it still appealing for consumers. Warnings and labels are used usually for the products that present higher risks for human health. And labels are so even though you don't identify this is an ultra processed food, which would be positive by identifying excess of some nutrients, you can also give the information that this food is harmful. In 2020, Anvisa approved a front of package labeling model. Although there was a set of evidence showing that warnings, whether in in the shape of octagons or triangles. Well, Anvisa actually adopted a magnifying glass model that reduced the footprint for those warnings. And according to information designers, the magnifying glass is not really a warning because it's not a recognizable symbol that can be repeated. So this is a model that actually doesn't really create a warning or a sense of urgency. And Visa also did not adopt the cutoffs that were suggested by the Pan American Health Organization. They decided to use three ingredients. So it would be high in sugar, high in sodium, and also high in saturated fat. So this is something that's already happening. I haven't seen it in person, but I saw some pictures of some products that were found in supermarket aisles containing those warnings. And since this is really not aligned with the Pan American Health Organization, the magnifying glass will end up identifying the foods with higher sugar content, but not really the unhealthy ones. Besides that, there are no bans on the use of nutrition claims. For example, rich in fiber or low sodium. So this creates a contradiction because some foods will be showing the magnifying glass saying high in sugar, and at the same time, there will be a claim stating that it's rich in fiber. And this is, of course, very confusing for consumers. At the same time, this was a very important advance, several years of discussions and several administrations were involved, and there was a lot of resistance from the food industry to avoid the adoption of the labeling. And we still have a lot of room to make progress. In relation to advertising, I would like to mention a few things. There are several possible ways of thinking about food regulation. And in spite of this, our progress has been very slow, and the current regulation has delivered results that are far below our expectations. Today, we have a national regulation that bans abusive advertising, but it's not specific to food, and this leads to litigation and different understanding among legal scholars. It's difficult to see the concept that advertising should not be directed to children and adolescents. Our Council for the Rights of Children and Adolescents also tried to define what abusive advertising would be, but we have a lot of issues both with the food industry and also with the advertising sector because they resist regulation. Nevertheless, there are several studies showing that advertising has a very detrimental effect and that children should be preserved from excessive advertising because this creates eating habits that will be something that will be adopted throughout their lives. And we also saw some advances in the Supreme Court. And those decisions and sentences, well, said that, well, it's actually a double-edged abuse because they were advertising products to children and adolescents, and those foods that were being advertised were ultra-processed foods. And as you know, this, of course, compounds the situation. And IDEC, the Institute for Consumer Protection, developed a joint strategy to strengthen and build capacity of the consumer protection agencies and also raise the awareness for the need to report abuses in that area. So we tried to promote the advancement of the regulation using the existing laws, and we have now a tool to receive reports on ultra-processed foods.
There are some denounces also of misleading advertisement, and there are some legal protections for that, or the Code for Consumer Defense. This leads to public debate on this topic. Just recently, we saw a couple of cases that have been published by the press, cases of misleading advertisement. And I believe this is important for information purposes and to think about the need for regulation. In spite of all these efforts, there's not a lot of room for debate about this agenda and about specific rules for ultra processed products. And there's always a debate stating that this regulation is just possible through legislative regulation, which is a difficult environment. Ultra processed foods that have specific regulation are the replacements for breastfeeding milk. There's a legislation that foresees that the commercial promotion and labeling of these products for newborns are either forbidden or restricted. And this legislation is broad, and the Brazilian equivalent to the FDA has to surveil and enforce these rules. We need to protect this regulation because it represents an advancement in protections for babies and families who are constantly harassed to consume formulas and composites with no need to do so. So this is an important example, a benchmark that allows us to think for other possibilities in terms of regulation. There are other important cases, regulatory measures to fight smoking. These are also examples on how to regulate food environments and ultra-processed foods. There were effective measures. They combine price regulation, advertisement, labeling, permission to smoke, or the lack of permission to smoke in enclosed spaces, indoor spaces. That was used to fight smoking. And this is an example, both for formulas and smoking, that can help us in find legislation for ultra-processed foods. Regarding government procurement, when it comes to ultra-processed foods, there was a recent advancements in the national program for meals in schools. There's a restriction on the procurement of ultra-processed foods, and there's a list of ultra-processed food that is forbidden for public procurement purposes. This is still being implemented, this legislation. PNAE is the acronym for legislation, and it's still being implemented after the return of in-person teaching, but it's a national policy, and it will be used as an example for other government procurement. I don't know how I'm doing on time, so maybe let me take a breath. Certainly, Anna. Yes, you talked very well about the advancements we've seen in terms of regulation for these three fronts we analyzed in our conversation. But there's still a lot to be done. You gave us the example of breastfeeding and formulas. Of course, there is regulation, but still harassment on babies and families and their babies keeps on existing, on this commercialization of products that are not necessary, but are introduced in children's or in babies' diets. When there is regulation, the industry reacts. You talked about labeling as well. So replacing sugar for sweetener. It can happen. It's natural that it happens because once there is a regulation, the industry then reacts to mitigate or sort of nullify the regulation. And that's a challenge for regulation. It has to keep updated and efficient. So now I have a second comment or question. What are the challenges we face when it comes to these fronts? We have regulation on advertisement. And from an Anvisa perspective, the Brazilian FDA's Anvisa, it's not efficient. Alexandre is going to cover this in the next panel, of course. Then there's also labeling. As you mentioned, its principles are not ideal. And from a government procurement perspective, we seem to have a more streamlined approach. So in your opinion, what are the next steps for the future? In your presentation, it was important to know what are the necessary adjustments. For those who work with law and legislation, we need to understand the tools and instruments that have to be improved in order to build appropriate public policies for food environment. So what are these challenges? Well, before I comment on specific policies, there's something we need to talk about, a discussion in law. There's an important discussion we need to have, which is how to identify ultra-processed foods for regulatory purposes. We want to use the OPUS nutrient model. It's a document which defines which foods should be the target of public policies or regulatory measures. And it incorporates this new classification. It establishes limits or caps for 6 substances. 5 are nutrients and 1 is an additive. And this is according to WHO recommendations. So it's an evidence-based model. It's based on this new classification, and it identifies foods according to sodium, trans fat, sweeteners, sugar, and other elements. There are studies being conducted to identify this. There's criticism among international researchers saying that this new regulation is way too broad, different characteristics, and saying that it's difficult to regulate and encompass all these characteristics. But when we use the OPUS nutrient classification, we can apply this to food labeling in Brazil. And we had a trained researcher identify ultra-processed foods. Then we used the OPUS profile to identify 95% of ultra-processed foods. And we add what we call cosmetic additives. Then we can reach 98 or almost 100% of identification of many ultra-processed foods. So that's a way of identifying ultra-processed foods, and it helps to build specific and encompassing rules. And I think this is an important point for debate. It allows us to think on how to move forward in identifying ultra-processed foods according to the OPUS model. We also have the PNAE, which is the program for meals in schools. They analyzed food prices, the feasibility of different menus for schools. So it actually incorporates the OPUS profile, but they adjust it according to the needs for meals in school. So that's also a possibility. Regarding labeling, many Latin American countries do follow the OPUS approach or PAHO approach. And that's much more effective. Mexico and Argentina, they have used the PAHO profile as a rule for their warnings. And there's also some items about advertisement and meals in school. So they combine several different policies. It's interesting to have such packages. In Brazil, the regulatory process itself was different. Many other countries have approved legislations with the executive or legislative branches. And here we have Anvisa, which is the equivalent to the FDA. It's a regulatory agency. They analyze the regulatory impact of these measures. And it's important to understand these models. It's important to master these processes because at the final stages of approval, we didn't have enough resources to actually have an impact in this process that was dominated by Anvisa in Brazil. When we look at the differences between the approved regulation and what was sent to public hearings, there were important changes between the two things. In the meantime, there were decisions made which, in my opinion, were not technically appropriate. The model of the magnifying glass, it was changed in the meantime. It's a model that was never tested in any research. So that labeling was never tested. But there's a sound regulatory process developed by Anvisa. That's how they justified their final decisions. But it would be important to better understand this model. There's also the concern with the nutritional profile. A nutritional profile that does not reach all ultra-processed foods. There's an immediate concern about the increased use of sweeteners. So this is an impact we expect will happen. And is there a possibility to review this? And how fast can this be reviewed? In the public hearing, Anvisa had talked about a staged implementation. There was a second stage, or a first stage would be softer and the second stage would be harder, but the second stage was eliminated. How can we then improve this implementation quickly? We should not be waiting for this assessment because there is evidence from other countries. We can look at labels and know how this will impact the Brazilian population. But the main point is to analyze how this information reaches consumers. How do people make choices when they look at this magnifying glass? That will rely on studies about consumer behavior and purchases. That's how we can analyze these impacts. Parallel to that, we can think of adding other policies beyond labeling. Other countries have done that. So, for instance, regulating advertisement, prices, and access in schools according to the magnifying glass and improving the magnifying glass so that it can encompass more types of food. Regarding advertisement, in spite of the advancements of legal decisions, they are very specific. Of course, we know this has an impact on companies' advertisement choices, but it's important to have this discussion about the role of Anvisa if we can regulate advertisement. We have a resolution, resolution number 24, which has been suspended. This would be important to build this path so that Anvisa can take this role. Currently, Anvisa, there was a destructuring of the area that was responsible for regulating advertisement. So we actually see a lack of interest of playing this role in Anvisa, and they take advantage of legal solutions and of the positioning of the General Counsel for the federal government not to regulate advertisement. But this is a very important front. If there is legal interest, I think it's important to move forward in that front as well. Regarding government procurement, of course, we have a decision, but there is difficulty in implementing this. The per capita amount for cities has not been readjusted. The president recently vetoed a readjustment in this amount. And cities need the structure, the technical support. They even need physical space to cook the meals instead of purchasing ultra-processed foods. So in spite of the existence of regulation, and this program for meals in schools, PNAE, is very well structured, but it's difficult to be implemented. There's still a lot of work to be done in order to implement this. Civil society is working on these topics, and we're going to hear more examples throughout the day, examples of work to protect the PNAE and also to foster the implementation of these measures. There's one other challenge with good perspectives in the new administration, which is having a political agenda for the topic. We hope to reach this, at least in part. It's important to think strategically how to move forward in this agenda. Restricting advertisement and some tax measures, they are the main priorities, I would say. And there's room for political advancement in these fronts. Ensuring that social participation is valued and is strengthened. We have different boards and councils for participation, and these spaces are important for public participation. And I want to mention the Alliance for Healthy Foods. I'm part of this alliance. This alliance has spearheaded many discussions with the legislative body. It's always difficult to move forward with the legislative branch. And another point I wanted to mention, having international commitments is important. They help to make national decisions at a national level. I've mentioned a couple of examples. For smoking, for instance, as I said, and also for formulas, we have framework conventions that establish regulations in different countries to fight smoking, for instance, and this really strengthens domestic work. For formulas or fighting formulas, we have an international code to protect breastfeeding. It was implemented by the WHO, and it's really important for the domestic debate. Of course, it's more difficult to have this international dialogue right now. Now there's this perspective of a dialogue with several stakeholders and players, but at the end of the day, we know this sometimes undermines the possibility of reaching stronger regulation to protect public health. And I also wanted to mention the challenge of restricting corporate political activities in companies that produce ultra-processed foods. These companies have organized political activities. They have strong lobbying activities against these topics. And sometimes they lead to political inertia. Sometimes they threaten or they harass representatives, and sometimes they put these topics they away. So they decide not to tackle this in the public debate. So these corporate organizations have to be regulated. They need to be transparent in their decisions. And these players should not have as much impact as they do now in influencing political decisions about public health.
There are several publications that reinforce that the methods used by the food industry are exactly the same as the tobacco industry to deny evidence and also to create a scare about the economic impact. So it's fundamental for us to be attentive to the interference of the food industry in our efforts. And I would like to share with you a message, some of the consensus that we obtained in the Josué de Castro fellowship that, for me, in my view, are very relevant for the discussion of food environments. I think that it's important for us to build regulation that is sustainable and also strong politically, something that really relates to the current scenario and context. And Professor Teresa Campello said that the cross-cutting themes such as inequality, gender, race, and age are some of the aspects that are interconnected and affected the more vulnerable fallacies. So regulating food environments is a way of ensuring we are reducing inequality for the low income population, building public policies to fight hunger, not only philanthropic initiatives, because we see a lot of room for example, for companies and ultra-processed foods present themselves as part of the solution, saying that they're going to make donations and get organized to fight hunger. And this, of course, puts them in a positive light. And another consensus is enhancing the role of the state as the agent for regulation and also social control, because the market itself will not take a leading role in the promotion of changes. So I think that this is more than a timely moment to deepen the discussion and identify possible ways to move forward. So thank you very much. I thank you for my time, and I hope that I was able to introduce the subjects for the day. Well, in terms of timing, it's really very good. We finished at 10:15, and now we have 15 minutes for the Q&A. I have some questions now. Okay, so let's start. Good morning, Professor Ana Paula. Thank you very much. What a great presentation. We got some comments and questions in the broadcast chat, and I chose just two of them. One from Larissa Lourdes, from Jeffas, FGMG. She asked, how will you enforce labeling and also advertising controls in digital media? I think it's a very interesting question because we know that there are ways of circumventing the implementation of these rules. And from Flavia Schwartzman, she asks, will the population understand the magnifying glass model? We know that civil society, represented by IDEC and other institutes, are proposing this, but what will be the receptiveness of the audience, and what will be the timeline for the implementation, and will the food industry benefit uh, from taking this opportunity for changing their strategies in relation to the foods that they put on our shelves? Great questions. Thank you very much. Thank you for the comments. Well, about the magnifying glass, this is not included as part of the Anvisa regulation because they look at the label description. But I do agree that this is a flaw. You can see, for example, that in several online supermarkets, it's not necessary to show the nutrition facts. So they just put it on the website. So, for example, as an example of that, for example, the need to identify GMO foods with the yellow triangle. In the online version, this is not shown by several corporations. And this is, of course, a very serious question now that there is such an emphasis on e-commerce. So it's great that Larissa commented on this. Maybe Anvisa could include this, or whether there should be a broader discussion on regulation and e-commerce, which I know is very challenging, not only considering food environments, but also other topics. So will people understand this magnifying glass? Flavio, as I said, there are no studies have been done so far, but we have a comparison with another magnifying glass that was larger and that was identified in a different way in relation to high content. So when we compare the magnifying glass to the triangle, we observed that the triangle was more effective, but the magnifying glass is better than nothing, of course. But we wonder whether this will be enough to really change consumption patterns. We'll have to wait and see and analyze behaviors. And in relation to what Fernanda said, this is very important, as I mentioned. Anvisa has established an implementation period quite long. The resolution was approved in 2020. We have now kicked off the time. Now the new products being launched, they need to show this magnifying glasses of October 9, and companies will have 1 year for the implementation. In these 12 months ahead, well, companies can benefit from that. I think this is part of what is possible to build in an implementation and negotiation process. I think that the timeline should be shorter. But I also think about examples such as Argentina. In Argentina, they had a shorter timeline, but there are so many exceptions that are being filed by them. So I wonder what is the necessary timeline to make sure that the new model will be implemented. But at the same time, I think it's a really long period of time, especially when companies can change their labels so quickly. When you see the promotions, for example, for Easter, for the World Cup, whatever, they change the label in a second. So why not adopt the magnifying glass sooner? I think even more serious is the case with beverages. They have a 5-year timeline because they are returnable packages. And Coca-Cola has just launched a new line of beverages focusing on this. This will extend implementation time. when, of course, you could have a separate label for that. There are several other options available, but this discussion on returnable bottles created this extended period of time for beverage makers. Another problem with implementation is uh, capacity building and enforcement by the surveillance agencies. We don't have much information available now, but it seems that they're not getting training on how they should act in relation to the new regulation. So this, of course, is also an obstacle. Thank you very much, Anna. Huge challenges ahead, and I think that they show, and the fact that you showed us these reactions really bear witness to the fact that regulation needs to adapt to the current context. Thank you very much. I am Marcos Lopes from the Pensar group, and Pensar, the research network on food security and safety. I would like to know how we can fight inequality in food environments instead of deepening it. In the case of tobacco, when you have fiscal measures, this means an increase in costs for consumers. We also have the challenge of teaching people, educating people on nutrition. So, especially, for example, in an inflationary context, uh, we know that the industry never plays a losing game. So, how will this, for example, drive more food inflation or a reduction in purchasing power of the low income population? So, how can we reconcile the regulatory agenda with the fight against inequality? Well, thank you very much, Marcos. I think this is a very important point in relation to taxation. I think that we can look up to other countries that have implemented taxation, and those measures end up reducing inequality because the benefits that are provided to the more vulnerable population far exceed any harm. For example, you are protecting the population from buying harmful foods, and you stimulate small production and other economic cycles related to healthier foods. And this creates even job opportunities for the vulnerable populations. So it's not only a matter of price, you should consider the changes, the chain of changes that occur in society. And ideally, it's important to build something that will not only increase the price of ultra processed foods, but that will also increase access to healthy foods. I think it's important to think of the combination of both. Healthier foods need to be stimulated, distributed. They have to be easily accessible. And when you think of other measures, for example, in school environments, quality nutrition in school meals is something that will ensure the proper development of the high vulnerability kids. And even advertising. Advertising has impacts in the lives of children that go much beyond consumption of foods. For example, they are influenced by images of social uh, ascension, race, and these are things that shape the behavior of vulnerable children in a much more vulnerable in a much more vulnerable way. So there are several ways of thinking about regulation that will drive a reduction of inequality. But you're absolutely right. It's important to have this discussion because it's really easy to say, well, prices will go up, but what about the more vulnerable population? So in fact, this is a very relevant discussion. Do we have any more questions? Well, while we wait for more questions, I have a question actually. Well, the analysis of regulatory impact, you said that this is something that prevented civil society from participating in the discussion. I found this curious because in regulation, the discussions like this are needed to legitimize the the choices made by regulators and legislators. You do a pro and con analysis, and through a structured decision-making process, you legitimize your decisions through that procedure, and this will lead to better decisions. So assessments of regulatory impact is a recommendation from OCDE, and I think that Anvisa was one of the first regulators to adopt it uh, massively. So what was the impediment that you had to face in this procedure? I think I need to think more about it, actually, reflect about it before I can express my views. But I have mentioned that the key impediment was in the final decision making step. Anvisa positioned itself as a mediator of conflicts. It was as if the civil society and the academia was on one side and industry was on the other side, and Anvisa was sitting neutral to pass a decision on this topic. I don't know if this is the stance a regulator should take in a public health issue. And I'm not going to say we didn't have any space for participation. Of course, we did. But at the same time, the official spaces occurred, and we knew the agencies and also the officers, well, they visited the associations of companies. They had bilateral meetings frequently with officers to show their point of view. So this is something that should take place in an assessment product. Why not have everything that was really transparent and open? But in fact, there were several parallel lines of discussion. So this role of mediation was something that really, uh, really annoyed us because we were defending the the health of the population. And this, in the final negotiations, we saw that the the parallel conversations with the industry continued to occur, and with civil society, what we knew is that we were not going to change much. Just the concept publica was, and those are, and actually the changes were not only minor. So it's not only uh, there's a political game. There were changes uh, in officers. This also made it difficult. I think that it's important for us to really give evidence its due weight, but this was not the result. The involvement of the industry as it occurred was not well balanced. It was not fully transparent as I think it should be, or like they set out themselves to be. Thank you very much, Anna. We have to keep to the time, so I would like to close Ana Paula's keynote speech. Thank you very much.
Good morning. I'm back. So I'm now going to give the floor to the presenters of the next panel on health, marketing, and advertisement, the role of regulation. It's going to be a pleasure to moderate this panel. I now give the floor to Alexandre Ferreira, Igor Brito, and Fabio Leite. Please feel free to wear masks or not when you are speaking, as you prefer. Okay, let me then introduce our panelists. I'm going to start with Alexandre Ferreira. Thank you very much for being here, Alexandre. Alexandre is doing a PhD in economic law and political economy at the University of São Paulo. He has a bachelor's and a master's in law at the University of São Paulo. He has expertise in public policies management and local governments. He has worked with regulation for the tech industry. Currently, Alexandre is a member of the GDPP, the Law and Public Policies Group. So he works in partnership with us. I give you the floor, Alexandre, and I'll introduce our other speakers when it is their turn. Thank you very much. Thank you, Isabel, for your presentation. It's a pleasure to be here with you. Can you see my presentation? So first of all, I wanted to mention that I was part of this collaboration with the support of the O'Neill Institute. And I'm going to present part of the results. I'm going to present part of the results of this work about the regulation of food environments in Brazil. I am one of the participants of this group, and I'm speaking on behalf of this group of authors. Many people have commented on this work: Adriana Carvalho, Alexandre Aragão, Ana Bortoleto, who was just speaking, Denise Lucena, and Oscar Cabrera. So let me show you our presentation. So as a starting point, we have this multidisciplinary idea about food environments. So there is a physical, social, cultural, economic perspective, and it's important to bear that in mind when we look at the elements. So food security, price, um, nutritional quality, and then we can understand what's the regulatory dimension. Where should we be looking at when we talk about ensuring the right to healthy food and nutrition? So that leads us into this part of our study, which is about ultra processed foods. There is extensive literature proving the impact of ultra processed foods in low nutritional value diets. And these diets are the cause of obesity and other NCDs globally. And that is a very severe scenario in Latin America and Brazil. So, how should regulation react to that? The goal today is to reflect about state regulation on the food industry in Brazil, looking specifically at the industry of ultra processed foods. Recently, connected to what Professor Diogo said in the beginning, there's an attack on the state's regulatory capacity. We have the legislation for economic freedom, which was passed in 2019. Let me tell you a bit about how law has been supporting or sometimes failing to support uh, regulatory policies for the food industry. I'm going to cover two uh, parts of regulation. One is connected to advertisement, and the other is connected to frontal labels. We mapped public policy initiatives coming from the Anvisa, the AGU, Senacon, and Cananda, different bodies in Brazil, and also the judiciary. There's a very strong positioning from the industry itself. How is the industry operating and what are the standards we observe? And we're also going to look at the civil society participation. So our analysis look at all these elements. And we also count on documents which we requested according to the legislation for access to public information. So let's start with advertisement, food advertisement. The context is of huge investments in the advertisement of ultra processed foods. We are constantly exposed to this advertisement, it's ubiquitous, and regulation plays a key role. So there's an asymmetry of information. So that's something legislation has to deal with. The asymmetry between the industry and consumers who make their choices. But there's also the role of mitigating externalities connected to the excessive consumption of these products, which has an individual and a collective impact. So we decided, or we've identified two important initiatives in terms of regulating advertisement. First, we have Anvisa's resolution from 2010, resolution number 24. And Anvisa is the Brazilian equivalent to the FDA. And the other aspect is advertisement for children. We have a resolution by CONANDA, which is the National Council for Children and Adolescent Rights, CONANDA. It's the acronym in Portuguese. So speaking about the Anvisa resolution, resolution 24. First, this resolution looks at disciplining the offer advertisement for food with high amounts of sugar, trans fatty acid, sodium, and also drinks with low nutritional value. Whenever this limit or this cap is met for these specific substances, there's the need to warn the general public about the consequences of consumption. So if you reach this limit, as an industry, companies have the duty of warning consumers about this. That has led into a situation we see as a pattern. Many legal opinions coming from renowned legal experts were elaborated. We've mapped actually 11 claims filed by private entities and also legal sentences or decisions that question the competence of the union to legislate on advertisement. They state that only the Congress can legislate on that. And the claims argue also that by doing this, the executive branch is limiting the freedom of speech that is present through advertisement. So these are arguments that are very common in these legal decisions. It's important to note that enforcing this resolution, actually the resolution was suspended. It was suspended due to an expert opinion from the General Counsel for the federal government, the AGU. The AGU had a provisional remedy suspending Anvisa's regulation and disputing the competence of the agency to regulate on that. So we have a body from the executive branch understanding or accepting the argument presented by these bodies that represent the advertisement industry. So there is this resolution from Anvisa, which is the result of public hearings. And then Anvisa questioned these decisions. But this is not reflected in all legal decisions. Most legal decisions against Resolution 24 are beneficial for the food industry. But in some cases, legal experts have acknowledged Anvisa's competence to regulate on the matter because we have the Code for Consumer Protection. CDC is the acronym in Portuguese for this code. And the legal branch acknowledges the importance of regulatory agencies. But the resolution is suspended based on this understanding by the General Counsel for the federal government, AGU. Now we have Canada's Resolution 163 about the abuse of publicity targeting children and adolescents. So Canada explains this advertisement that takes advantage of children and adolescents. And again, Canada is the National Council for Children and Adolescent Rights. Canada is the acronym in Portuguese. And that's an attempt to put in place decisions from our constitution or elements of our constitution. This has been really important for advertisement control activities. And again, we see the reaction of the industry, of the food industry. Once again, they argue that legislating on advertisement is a competence for the Brazilian Congress, that no other body or regulatory agency can regulate on that. And that the CONAR, which is the self-regulating body for the advertisement industry, would be enough to regulate on abuses. So the industry always creates this narrative. Resolution 163 is extremely important, but this has had an impact on other fronts. And I would like to highlight three things. One is an initiative of the Senacon, which is a federal body. They oppose to this Canada regulation. So it's trying to balance children's and adolescent rights with advertisement. Then we have a bill, Bill 168, that tries to hinder Canada's power. And then we have a 2019 decree from the federal government also trying to hinder Canada's work. But this was partially suspended by the Brazilian Supreme Court, the STF. So the industry presents arguments, and these arguments end up being backed by the federal government and its bodies, its institutions. There's a recent element to this debate. We have a state legislation in the state of Bahia that forbids communication targeting children, mostly looking at elementary schools and daycare. And this is very similar to Resolution 24 we've just mentioned. The idea is forbidding advertisement targeting children. And this was questioned with the Supreme Court. But the Supreme Court says that the legislation in Bahia is constitutional. And the Brazilian Supreme Court discusses the resolution which was suspended by the AGU. So that might bring a new perspective on Resolution 24. So there has been a lot of back and forth in this topic regarding advertisement targeting children. Now I wanted to mention two cases connected to advertisement. This is about the process of reviewing front labeling rules. Ana Bortoleto mentioned this earlier. So there is this consensus that regulating, standardizing, and normatizing labels or front labels with nutritional facts, this is really important for eating habits for families. It is both connected to healthy diet and to the right to information. Science and research shows that this is really important, and we have research on Latin America about this as well. This is really important in a context with a low-income population, such as ours, that needs information and even warnings about the risks connected to some eating practices. So this is a fundamental right in the Brazilian context. There are three standardization techniques I highlight here. The first one is interpretation. It's a direct warning to consumers. As Anna mentioned, we have the triangles that state this food presents risk because it has some high value substances. Then we have the semi-interpretation, which is the magnifying glass or like traffic lights with red, green, and yellow. So this takes some interpretation from consumers. And then we have studies saying that informative models are important. They have a direct connection with eating habits. But still, the industry opposes to that at the local and international levels, at the Mercosur or in international foray about labels. So there's a lot of resistance from the industry regarding labels. In Brazil, some rules were reviewed. This process started in 2014 with Anvisa and the civil society. Many government agencies believed that the existing rules were not enough to ensure proper right to information and to a healthy diet. And in 2020, at the end of this process, there were new rules standardizing frontal labels with the magnifying glass. When you have high levels of sodium or sugar, and they go over the limit. So the option was to go for the magnifying glass. And we see similarities with the rest of the debate about ultra-processed foods. So throughout this regulatory process, we've had the creation of an Alliance for Healthy Food that brings together experts and civil society. And then we also had the creation of the Freedom Network, Rede Liberdade, which is a coalition of associations from the industry. They are very organized and they're still active even after the resolution. They start with a reactive narrative against the regulation, but with time, they define semi-interpretative models, such as the traffic lights. And I'm going to show you the image in a minute. Anna has talked about this already. And in 2018, throughout the regulatory process, this process was actually the first with Anvisa that is in the framework of the economic freedom legislation. This legislation foresees public hearings. So this resolution operates under this logic. So in spite of this broad public participation, in 2018, Anvisa had said that they wanted this direct model of direct alerts. But in the end, they adopted the magnifying glass approach. And we see this concern with avoiding alerts, avoiding a paternalistic behavior with consumers. So there was a pivoting at the end of this process. Just to give you an idea of the different communication approaches, on the left-hand side, we have the triangle warnings. It's a direct warning proposed by the Alliance. And on the right-hand side, the traffic light model. You might have high, medium, or low levels of nutrients, and this is an indirect way to communicate with end consumers.
And this contradicts the experience in Latin America and also Paulo's suggestion. So therefore, we had some incremental advances and also some setbacks. But the final labeling model also presented critical ingredients. We didn't go into the fact of what is an ultra-processed food or not, which is something the civil society wanted, but Anvisa considered that it was not the right time. And another very important point. So the resolution is for 2025, diagnostics for 2014, resolution 2020, and it will come into force by 2025. So as you can see, it's a scaled approach in relation to effectiveness. And even though this is a more recent process, we saw that the Ministry of Finance, through the Secretariat, that had been acting as a gatekeeper for economic freedom and also some mechanisms to receive reports. So the Secretariat contributes to the process by saying, we recognize the potential benefit of the measure, but Anvisa, it's very important that you monitor this and comply with the economic freedom law and the regulation pertaining to it so that it's not offended in relation to the benefit in public health. So this is something that will accompany the implementation. So this is an image from IDEC in which they compare how the warnings shrank during the process. So for the end consumer, the impact is much lower. So I think that my time is almost up, so I'll try to be brief. So what are the final considerations considering advertising and labeling in Brazil? And in fact, there are many similarities between the two. Elsewhere in the world, they are treated in very similar ways. We try to do it, but we do not succeed. So this is a first pattern of participation of the industry. This is something that we need to consider, local and international organization. Here in Brazil, we always try to use self-regulation as a sufficient mechanism for the protection of consumers. But in fact, what we see is a systematic challenging of the jurisdiction of the organs and the agencies involved, even in partial understandings, like, for example, the General Counsel for the federal government suspended an advertising rule, but we see some federal government agencies being mobilized as a way of controlling the industry-wide regulation. So, for example, General Counsel for the federal government, Senacom, and the Secretariat are saying, well, this is a regulated sector, so and this, of course, will create very strong consequences on the regulated environment. So, in the context of the Economic Freedom Act, we have some figures, for example, the abuse of regulatory power, which is a risk to the security of regulation. So, this is what we believe. From now on, after we have mapped out all the actors in the sector, are we moving towards flexibilization of the ultra-processed foods sector? This is something that we should leave open-ended, but what we see is that there is a transition on the way and a change of directions, especially considering the federal government. So we're looking at competencies and also the stance of the federal government. There are several ways, some course adjustments that are not really very complex. So finally, this is a summary chart in which we see the two pillars, labeling and advertising, as competencies in which, of course, there is an attack against regulatory power, confronted with this concept of economic freedom. But this is something that we have to deal with. I think these were the main points of my talk. I thank you all for your kind attention. And now I turn over the floor to Isabel and the colleagues. Thank you very much, Alexandre, for presenting this survey. I think it was very interesting what you said. You were talking about the fact that you showed us labeling and the cases of labeling and advertising was something that was very clear, very easy to understand. So if you're watching us from home, please take note of your questions. We'll have 3 presentations, and after that, we'll have a space for discussion. So now I will introduce Igor Brito, our next panel member. He has a master in fundamental rights from the University of Victoria. He has a PhD from Coimbra University, besides other PhD. He's a consultant of uh, corporate law, over 20 years of experience in consumer protection, and he is the deputy officer at IDEC as well. I turn you over the floor, Igor. Good morning, everyone. It's a great satisfaction for me to participate in this very productive discussion that was promoted by the O'Neill Institute together with the Public Policy Institute. Isabel entrusted me with the task of offering you IDEX perspective on very some advertised cases in the area of food marketing and advertising. So these are some of the cases in which we were involved together with other organizations and that had high impact in Brazil. So we want to share with you our assessment on how the judiciary has been. Okay, should I press enter? Okay, so we're going to give you our take on how the judiciary has handled in the past 6 years cases that are related to the food industry when they are prosecuted by consumer protection agencies and also when they are challenged by the prosecutor's office in the case of misleading or abusive advertising of food products. So the cases I chose for my presentation are not exhausting. I mean, that there are several other cases related to those issues, but they are either high impact cases or cases that make the headlines because they can be seen as a paradigm or that have received special attention by our legal scholars. And I will now take the liberty of sharing with you this reference. This is a small book that I wrote in 2010. And the reason why I chose this book, well, back in 2010, there was a very small group of legal scholars that were trying to understand and make a contribution in a conflict that was becoming prevalent in Brazil. For example, the well being of children and also the right to advertise. In 2010, there were no precedents in our courts relating to the regulation of advertising except for tobacco. So there were, so there was this, health protection and consumer rights were the object of public policies and also civil rights defense in the area of smoking. So the topic that was actually more beneficial to discuss the limits of and the freedom restrictions was advertising directed to children because there was a lot of repercussions in that regard both in Europe and in the United States. And in Brazil we had Institute Alana that was introducing this discussion in Brazil, and that was able to create some noise also in high-level litigation. So all important lawsuits, whether in the Supreme Court or in the STJ, are directly related to the right to healthy food and diet. They were all derived from the advertising to children. So what we can identify is that there is a very strong connection with protection of children and the fight against child obesity. The two topics, of course, are deeply linked. And I'll share some more recent cases with you, some very important cases for IDEC. And here we will see misleading labels, and there is also a strong background in our legal sentences in relation to the limits of advertising of and misleading claims. So the RDC 24 that Alexandre has just commented on was just being published at the time, and there was a very optimistic climate. We hoped that we would have an initial regulatory strategy to impose limits on advertisers beyond alcoholic beverages and tobacco. So as Alexandre has said, RDC 24 is nothing but an embryo of ideas coming from a very qualified team in Anvisa. They had to fight against one of the strongest lobbies in the regulatory body. I cannot even remember, such a strong interference, because Anvisa at the time had a unit dedicated to regulating advertising, and one of the deliveries they made was the RDC mentioned by Alexandre. And at that time, Anvisa didn't have the high level of regulatory practices, assessments of regulatory impact, but it was this pioneer, the pioneer of, best social practices. And just to say, of course, just to summarize, RDC was written with the best quality possible in rulemaking in Brazil. There was participation, public hearings. So the unit, the advertising unit, felt on their skin the interference. So the consequence of RDC 24, besides the avalanche of lawsuits that Anvisa received, and today there are about 2,000 public servants at Anvisa, they are completely traumatized by this barrage of lawsuits against them. So I'm at a loss for words, but it made them fearful. I think that, fearful or wary of is a better word for what they felt whenever they are passing a decision or a technical per paper. They fear judicialization. So there were some civil servants that had been approved by the public admission tests, and for them, the regulation on advertising was their baby. And as a consequence of that, they felt completely discouraged. The positions were just eliminated, all their work was undone. So the civil servants who had worked so far were distributed all over the place, and today they're almost on a gag order to to talk about the limits for advertising. But that was a very optimistic time because they were just finishing, and it was before this avalanche of lawsuits and even before the extension of this unit, the Anvisa unit that dealt with advertising regulation. The discussion in legal doctrine and just a handful of case precedent revolved around a conflict of freedoms, the freedom of a consumer to choose, because advertising is seen in that area as an activity that free but that needs some limits, otherwise it could interfere in freedom of choice. So, because advertising is about convincing and persuading, and wherever in the world that there is consumer protection, there are some rules that are established to protect the right of consumers to freedom of choice, freedom of decision without suffering any manipulation. On the other hand, there was a strong trend at the time of adopting the American doctrine of strengthening the fundamental rights of legal entities. So it was not only about the economic right, but it was a fundamental right to advertise and to express their opinion, something that was called freedom of commercial expression, both in Brazil and in the US. So, in this clash against doctrines, corporate rights on one side and consumer rights on the other side, and in Rio de Janeiro at the Federal University and the State University, there was a lot of discussion. Many papers were published around this. They were discussing what freedoms should prevail, and there was a conflict in constitutional rights, both the individuals and also the corporations' rights to freedom of expression. So the concept of abuse in advertising as a limit for the right of corporations was never enough to give us the legal security we needed in our decisions. So consumer protection always required that we look at other important rights when defining consumer protection. For example, health, in the case of tobacco, which is something that we see also in food advertising, the right of children, the right to education. And this is the framework that establishes restrictions in advertising. There's another element that's very important, and that is camouflaged in the decisions and sentences. And I think that there is a backdrop discussion is dominated by the concept of family, of the family that should also be seen as a food environment.
Those who fight for broad freedom for advertisement and advertisers, when it comes to advertisement targeting children, they state that advertisement can be targeting children and food advertisement can target children because at the end of the day, the decision makers are the families or the parents or guardians. They decide what are the eating habits that will be transmitted to the children. At the same time, those who defend more severe and clear limits for the advertisement industry, they also use the family from a constitutional perspective or the social values of a family. They state that the excess of food advertisement targeting children, it hinders and interferes in the family's freedom to make their choices. This is an interesting dichotomy. In the doctrine, this dispute already existed. Who would use families' rights to fight for their interests, either to make more advertisement or to limit advertisement? But this was not present in jurisprudence. In 2016 and also 2017, we had major decisions by higher courts. It was the first time that a court of appeals talked about the limits of advertisement. And the Brazilian court, the STJ, went beyond other topics such as alcoholic beverages. They went beyond topics foreseen in our constitution, such as medication, alcoholic beverages, and tobacco. And they talked about this because of legal claims that were concerning advertisement of ultra processed foods targeting children. And healthy nutrition appears with a subtlety in these decisions. It's not properly approached in these decisions, the decisions from 2016 and 2017. In 2016, we have a class action uh, against Bauduco. And in 2017, it was a legal lawsuit from Procon, the consumer rights organ in São Paulo, against providing gifts and children's characters to attract the attention of children so that they pressure the family to purchase ultra processed foods. In both cases, and I have highlighted this in the slides, and I hope you can see this. In spite of the fact that these decisions do not treat properly these policies or the problem of child obesity, their foundation in the two cases is the protection of family. They state that advertisement cannot target children directly. Ultra-processed food advertisement cannot target children because family members are the decision makers. And the logic was strengthened. It says that since children don't have the civil capacity to make eating choices, advertisement then should not target children directly. This is important to show that the topic of food environments or the right to appropriate diet is tackled on the surface here in both cases. I'm going to show you a case in the Supreme Court that judged the constitutionality of the state legislation in Bahia. Alexandre just mentioned this. So experts in consumer rights and even legal experts or experts from the public prosecutor's office and from bodies that protect consumer rights, they really want to move forward in this agenda for consumer rights. And they have the best potential to reach restrictions on food advertisement. But they still do not show deep understanding about the human right to an appropriate diet or to healthy foods. So we still need more dialogue between these experts, professionals, and the doctrine, uh, which is a problem. The further apart they are when they discuss consumer rights and the right to a healthy diet, the more this argument for the freedom of advertisement will be presented, or the stronger this argument will be. Because we need to have stronger fundamental rights. And the right to a healthy diet is one of these fundamental rights. And I wanted to show the lack of understanding about food environments and how this is an important legal instrument in judicial debates about the limits for advertisement and the advertisement industry. There was a decision by a judge, Judge Vicente de Abreu, on a case filed by Procon, the consumer rights body, versus Sadia, the food production industry. Sadia wanted to nullify a penalty applied by Procon because Sadia was providing gifts with their food during the Olympic Games. They were fined, and this case was judged by a higher court in 2017. They proved that it was abusive advertisement and an illegal marketing strategy. But the higher court in the state of São Paulo at the time, they make a huge confusion between urban environments and food environments. I don't know if you can read this in the slide, but the court states, or stated at the time, that there was a huge inconsistency in wanting to limit or create rules for food advertisement, industrialized foods. They don't even talk about ultra processed foods in their decision. But there's a confusion between urban environments and the provision of ultra processed foods, stating that this is typical of the society of consumption and that law cannot regulate or create limits or restrictions. So it would then be inconsistent to limit the advertisement of industrialized foods. That's the term they use in an urban environment. So this just shows how the Brazilian legal system is far removed from this concept we are debating here. I would also like to mention another interesting example. It shows attempts from public bodies, bodies for consumer rights, to create this agenda on regulating advertisement, an agenda to regulate advertisement and also to reach healthy food environments. And they're immediately opposed. There's immediate opposition by the food industry. And the opposition is immediately confirmed by Brazilian courts with low quality reasoning. This was the first time Senacon worked on a technical opinion. And this was a technical opinion that stated to consumer bodies all over Brazil, it stated that ultra-processed food advertisement in schools violates the Code for Consumer Rights and violates children's rights. And they encouraged consumer bodies to read about it and to enforce this legislation in schools. But the company Mauricio de Souza Produções, a Brazilian company, decided to file a suit against this technical opinion. And they requested courts to actually censor the technical opinion so that Senacon could not even make this public. And they managed to get a provisional remedy. which was upheld by a court of appeals in Brasilia. And this technical opinion used for the first time the concept of ultra processed foods. And then this federal court of appeals, they saw this as a problem. They said that Senacon could not use the concept of ultra processed foods. It was the judge's understanding that this concept is not used by the Brazilian public administration, and therefore Senacon could not use the concept. The technical opinion's goal was just meant to explain what ultra-processed foods are. I know that I'm running out of time, so let me finish with a final example here. Actually, two final examples before I give the floor to Fabio. There was an important recent case on the Brazilian Supreme Court. It was an inconstitutionality claim. But they state that the STF, the Supreme Court, decided that the legislation in the state of Bahia is constitutional. And this state legislation forbids the advertisement of ultra-processed foods in the schools of the state of Bahia. Then an organization representing advertisements filed a claim So I'm sorry, I forgot the name of the body, and I'm asking our colleague here to help us. So this association that represents advertisers, Aberti is the name of the association, they filed a claim for the unconstitutionality of this legislation. They stated that states cannot regulate on advertisement because this would fall under the competence of the federal government. However, the Supreme Court decided that the state legislation is constitutional. They ruled that states and cities can create rules to restrict advertisement within schools. So here we do see clear protection to this human right to healthy nutrition. There is no direct mention of this in the decision, but the concept is expressed here. They talk about food with high level of specific nutrition, and they make reference to the protection of families. The Supreme Court believes that in schools, children are not accompanied by their legal guardians. So once again, they use family as an instrument for the protection of children. But there's a dangerous aspect here. It was the first time this happened. And then there was a case about the advertisement of tobacco products. But here the Supreme Court states that advertisement means freedom of commercial expression, which is a problem. Two recent cases with a ruling by the Supreme Court in favor of this theory that the right to advertise is a fundamental right. So we actually need more fundamental rights. And then this becomes a debate on balance and conflicts between different principles and different constitutional interests. There were other cases I wanted to discuss here today, more recent cases, but I don't have time. I know my time's up. But this is a case here that is an example of a new trend we see. The judiciary is having a different understanding about misleading labels or misleading brands. This is a recent case and a recent victory we've had. Coca-Cola has adopted this strategy of using unprocessed foods such as water or fruit juices, and they make use of these concepts in their brands. And uh, they label soft drinks uh, such as Aquarius Fresh or Del Valle Fresh. These are products that have a very high rate of preservatives, sweeteners, and other critical ingredients, and they sell them as if they were not processed foods. They present them as healthy drinks. And now we see a stronger understanding from the Brazilian judiciary to forbid this type of practice. It brings us back to a discussion we've already had in our country about the freedom of brands to use misleading information with consumers. But I guess this can be the topic for another forum. I know we need more time for debates, and we're going to have more panelists. I know. Thank you. Thank you very much, Igor. Alexandre had talked about law as a place for disputes and controversies, and you really went into the detail of legal narratives. What are the concepts under dispute? Abuse or violation, and the balance between different consumer rights, the role of the family, and different sides making use of these concepts. So it was a great contribution. It really sheds light and shows from a practical perspective how these legal narratives are built and how they come up in different cases. So I now give the floor to Professor Fabio Leite. He has a PhD in public law by the State University of Rio de Janeiro. He has a bachelor's degree in law by the Catholic University of Rio, where he's currently a law professor. He coordinates now a group that studies freedom of speech in Brazil. Their work has been mentioned at several courts in Brazil. So, Fabio, I give the floor to you now, and thank you very much for being here. Thank you very much, Isabel. Good morning, everyone. I would like to salute my colleague panelists, Alexandre, Igor, Isabel. I'm going to be brief. Rest assured that I'm going to be brief as the final speaker of this panel. Some points have already been brilliantly presented, and I don't want to be repetitive. As Isabel mentioned, for more than 10 years, I've been researching on freedom of speech. And I believe that's why I'm here in this panel today discussing healthy nutrition and consumer rights. And from this research about different fields of freedom of speech in elections, in the press, or connected to hate speech, many different areas connected to the freedom of speech. And that has led me into a partnership with the O'Neill Institute, where we have been conducting a research for the last year about advertisement. At least that's the part I'm researching about. And I will speak about this research, but please, I wanted just to make clear that I'm not the only researcher. There is a team of researchers, of course. I don't think researchers work alone anymore. So, I would like to make some general and brief remarks about freedom of speech, because this is really important for the specific topic of our panel. We have some problems connected to freedom of speech in Brazil. The lack of specific concrete rules. Of course, it varies from one topic to the other, but this is an ongoing problem. We have some vague constitutional mechanisms, and sometimes we have parameters that are not really helpful. People feel satisfied, and the academia keeps repeating that there's need to create parameters to deal with the freedom of speech, whether from a commercial perspective, from a freedom of press. And these parameters are studied by scholars when the problem is that these parameters have to be considered by the interpreter. Many scholars present these parameters. Some say that I am providing parameters or standards, but they have to be interpreted. When the person interpreting considers the parameters, they can do whatever they want. The only thing they had to do was to take the parameters into account. And there's always the but or the however. You can never say this is wrong or this is right because there's no rule. There are no rules. For freedom of speech cases, in a broader sense of the term, it's very hard to say whether the decision is right or wrong. So, one of the points of my study is decision making processes about freedom of speech. That involves looking at how judges decide on that, looking at different experiments and looking also outside the law environment. One thing is for certain: it's very difficult to make legal decisions when the rules are not clear, when we only have vague mechanisms such as consumer rights or family rights or all encompassing concepts such as abuse of rights. We might have binding decisions, we might have doctoral theses. So if tobacco advertisement is forbidden, then that leads immediately to another decision. But these public figures have less protection. But what is the rule that will tell us that this is lower or higher? Whenever everyone says that public figures have lower protection to honor, well, judges are public figures, and their honor is higher than anyone's. That's because you were speaking bad things about judges. That's why the microphone stopped working. Well, almost 100% of the cases, and there is the compensation for non-judges is 16,000 reais, and compensation for judges is 60,000 reais. So we must think of rules. Of course, this is about a diagnosis of this area from my perspective, thinking of measures and strategies to face the problem. So it's important to consider that we do need rules to deal with a problem. And I think it's important to have this knowledge. In Brazil, we have a different problem regarding freedom of speech, which is maybe an equivocate approach which does not differ between different categories. It's important maybe to talk about freedom of commercial speech because we really don't work with categories. So, freedom of speech is a fundamental right that is seen in a way that is all encompassing for any field, for the press, for the election. So, we don't draw any differences between times, places, time, manner, and place, as the Americans say. And that might make a difference. During elections, there might be greater restriction to freedom of speech, and the freedom of commercial speech can be helpful.
Commercial freedom of speech is different from freedom of speech for the press or for the arts. It's a different category that should be treated differently. I like to make references to the United States because in Brazil there is a mistaken idea that freedom of speech is absolute. If I got a penny for every time I hear that, I would be a millionaire. But in fact, it's not easy to deal with freedom of speech in the United States. There are different categories. For each categories, there is a set of rules not based on laws, but based on case precedent. So in the case of freedom of speech, ironically, people believe that in the United States, this is absolute and something that's provided by the First Amendment. But in the case of freedom of speech, they apply what is called an intermediary scrutiny. It's not the strict scrutiny where, the law is born under a presumption of inconstitutionality in relation to the strict scrutiny. It has to be something that's very clearly justified. But when it's intermediary scrutiny, it's not as simple and not as complex. Of course, you have to consider the lawfulness of the activity. Then there are 3 points to consider. But if you compare it to the principle of proportionality, you don't have to, according to the precedent in the Supreme Court. Central Hudson is the name of the case. This is where they established the precedent that limits commercial freedom of speech. We know that the principle of proportionality has a fit for purpose, and but in the case of need, it doesn't have to be the more restrictive means. There is no need for you to prove, because it's sometimes very difficult to prove, this is the less restrictive means to attain your result. It's going to be constitutional anyways. If there is another means that is less restrictive, this has no bearing. The commercial freedom of speech can be deemed constitutional. I'm not saying that the United States is the best country, but it's ironic to think that protection to freedom of speech is broader in the United States. And in fact, protection could be lesser than what we have in Brazil when you apply the principle of proportionality as if you, in the case of artistic expression or other types of free speech. In our assessment of Brazil, we looked at the forms of control of advertising, such as CONAR, PROCOM, the Consumer Protection Agency. We didn't look as much into that because most of the cases eventually lead to litigation. In the CONAR case, which is the self-regulation agency, we have over 600 cases that were submitted to CONAR in a decade. So I won't spend much time talking about it, but maybe even in next year, I don't think we're going to give much attention to this because we can challenge really the efficacy of CONAR. It's a group that defends corporate interests. they have a very well organized in which you have, for example, the different topics, children, adolescents, the elderly, CSR, but most of the cases, the overwhelming majority ends up by being filed without any progress after that. So this is a good way of summarizing the CONAR's activities. And CONAR has 200 cases a year in France. The self-regulation agency for advertising judged, I don't know, 1,300. Well, these are just numbers. I'm just trying to justify how uninterested we are in taking a deeper look at CONAR. We also looked at the Supreme Court cases and the STJ, the Superior Court of Justice case. In STJ, well, they have special appeals being judged, and this is a law that not specific for that case, even though it's a customer or a consumer facing law, and you have the concepts of abuse or misleading claims, but this is not something that's specific to what we are doing. So you have actually to twist things around a little bit so that you can really use those instruments. So that's why what I'm trying to point out here is that we need rules that are more specific and that look at the trees rather than the forest. I'll talk about two cases that were tried by the Superior Court of Justice. The Shrek Watch was judged, and also the Sadia mascot that was judged in 2017. Well, in the case of the mascot for Sadia, this was a promotional activity for the Pan American Games in Rio. An important point. In the case of the Shrek Watch, STJ confirmed a sentence by the STJ São Paulo. In the case of Sadia, they actually overturned a decision by the São Paulo STJ. So I'm not saying that it was the same people who were involved, but STJ argued that the Sadia products, I don't know, sausages and ham, they're products for adults, not for children. But that was the point, and they actually circumvented that understanding by saying that they were products for an adult audience. So here, the decision was overturned back in 2017 and then in 2019, and this was for the it was a very similar case to the Sadia case. So in this case, the Superior Court of Justice of São Paulo, and it involved the Del Valle juice company. I don't know, they were giving out some toy, and there the justice agreed with the São Paulo decision, saying that Suco del Valle is for an adult audience. So the STJ doesn't even talk to itself. I would like just to clarify that it's only natural for judges to take that approach, but they won't even refer to the decision that became so popular or so well known. So there are no new arguments. They're just rehashing the arguments. So we have this problem with the STJ. And it is possible to establish a rule, the rule that could be used for Sadia or for Shrek. For all three cases, what matters is not the target audience, but rather the giveaway that comes with the product. So how am I doing on time? So I'll try to be very brief. Another interesting development, gluten. Well, our research looked at 5 years. I think it's, I think you're getting an interference there. So in the case of the STJ, we looked at 12 sentences in a special appeal where the were two associations, by the way, based in the Midwest of Brazil, which is they didn't want products to show the information that contains gluten. They wanted the warning that gluten is harmful for people with celiac disease or other conditions. That was a strategy that two associations spearheaded, and from the 10 lawsuits, rather from the 12 lawsuits, 10 were in the state of Goiás, and actually there were just two states, Mato Grosso and Goiás. So the association was founded precisely for that purpose because, you know, there was this problem. This association was only 1 year old, and therefore they didn't want, they couldn't really file a lawsuit. So there was always the same defendant, and they wanted the warning saying contains gluten, which is an obligation according to the legislation, but they wanted the warning that gluten is harmful for those who have celiac disease. So the association, they didn't succeed under this argument. They were under a year old in the Superior Court of Justice. They won the case. I don't really like this, you know, this requirement that you're at least 1 year old. But at any rate, the Superior Court of Justice, well, first they considered the case not relevant, but according to the law, it says, well, it should contain the warning, it contains gluten. And the STJ, when interpreting the legislation for a case that I cannot really give my opinion on, I don't know what to think about it, because one of the arguments, and this is my metaphor, so it's as if contains shrimp. It's just as if you're saying, well, shrimp is harmful for people with an allergy to shrimp. So, so the the claim was denied because celiac disease is, you know, contains gluten. If you see contains gluten, if you're celiac, you know already this is not a product for you. So I'm not criticizing the decision, but the fact is that the Superior Court of Justice in this case went beyond its mandate and uh, gave more importance to the right to health. So there were two cases in which the case were judged without grounds, but and then the special court judged another case, and they just abided by the case precedent of the special court. So this is something that has been widely accepted at the Superior Court of Justice. I will close now, but in relation to the Supreme Court, well, we've talked about the inconstitutionality lawsuit in the state of Bahia. This created an avenue that was it is really important, but it's not. It's something that it's not clear to me. What I see in the STF is precedent on state decisions. The federal law of I don't know. Law, I don't know what number, article one number. So the federal law, federal laws do not establish any limits in relation to advertising because there is no progress in Congress. So the precedent is issued from the state decisions. and the unconstitutionality decisions hail from the fact that the states are not qualified to judge that. So this is exactly why we have so many inconstitutionality suits. And so I'm not saying that the states are wrong. In fact, the subject is very hazy because it involves competing jurisdictions. Well, I had the opportunity to say that, you know, we're going to have to deal with this, and we have to talk about competing jurisdictions in the area of consumer law. What's the role of government? And then I had a look. I looked up a certain uh, inconstitutionality lawsuit, and it was one that was passed 11 years ago. And I think that this is the role of the academia. In fact, instead of writing a new thesis on federations, why not write about this? Everybody knows how the Brazilian Federation and the American Federation compare. But as a professor of constitutional law, I have to say that competing jurisdictions is something that's very confusing, and we're just postponing the problem. Maybe we cannot really move ahead of a constitution, but rules have to be defined, and the states want to legislate this. But what creates, in most cases, we have the confusion being case, for example, in the labeling of coffee. In Santa Catarina, it's allowed to pass some requirements on the labeling of coffee, but not in the state of São Paulo. So we need to establish a universal rule. And just to close, Isabel, I read the 311 inconstitutional lawsuit. This is a very interesting decision, even though it's quite long. But the problem is that when we have a decision and several reasons for it, we don't really know how this will work as precedent. So when there are multiple reasons, we don't really know how to use this as precedent. In the next case, things won't be the same. This is meant as no criticism of the decisions. In that case, they wanted to address the legislation related to coffee. I think that the credit goes to whoever drafted the law and to the civil society, whoever researched this. So I think that the Supreme Court should not get the laurels in occasions like this when they are just confirming that a certain piece of legislation is constitutional. I remember Minister Aires Brito, when judging the safety law, they said, well, this will make the annals of history. And the Supreme Court just said that this law is constitutional. There were so many public hearings. The government was really supporting this law. So why is it that a decision by the Supreme Court saying that this is constitutional that should go into the annals of history? The same goes for tobacco, for example. So they're just standing still until the law catches. And so it's great that they issued an opinion that it's constitutional, but they should not get any credit for it. And my interest was, what can we use from that and apply to other cases? So there was an opening there, the application of the proportionality principle. And here, of course, the rigor in the United States is not as strong. Here, use the principle of proportionality in a very strict way, and they don't get as far as balancing there. Well, I promised that I would be brief. So just like Fidel Castro used to say, I'm sorry, and thank you so much for your attention.
Thank you. So this is a hermeneutics debate. Reaching this level of debate is really interesting for our conversation. We are actually out of time for our lunch break, and we cannot be late because we have the live stream for those who are watching remotely. So we have time for just a couple of questions for our panelists, and then we can finalize. Can you hear me? Good morning. Good morning, everyone. Congratulations um, for your presentations. My name is Beatriz, and I have a question that is connected to Igor's presentation, but of course, everyone can make comments. I really liked your approach about advertisement targeting children and the connection you made with family. I'd never thought about this. We go back into this past perspective of separating the public and private realms. And this goes beyond advertisement targeting children. It reaches education, I would say. You got me thinking about something that might cause an impact. What is the impact for advertisement targeting children? If you think about regulating food environments, what is the impact of the decision for the Data Protection Authority when it comes to processing data from children and adolescents? The Brazilian legislation, LGPD, has a very limited legal foundation on processing children's data. We all agree, I suppose, that that's not the only legal foundation. But I'm concerned that the Data Protection Authority is thinking of broadening this, processing data for credit purposes or legitimate interest. Can you talk a little bit then about the impact this might have on advertisement targeting children, most of all when it comes to food regulation? Thank you very much. Maybe we can ask a second question. Thank you, Beatriz, for your question. It's an excellent and challenging question. I was looking at my colleagues so that they can help me, my colleagues from IDEC, the Institute for Consumer Defense. I wouldn't say I have an institutional stance on this. It's more a personal perspective, but it might have impacts in IDEC's perspective. I have a critical perspective on the progress the Data Protection Authority is taking. I do respect the legislative process that led to its creation and its structuring, creating this autonomous body in Brazil. We were part of the process. We presented many proposals on how the National Data Protection Authority could be created, but I think the creation of this authority has been very slow. And this slow pace means that this authority is then subject to omissions, we expected them to be more active by now, especially when we look at vulnerable audiences, our vulnerable citizens. In the consumer defense realm, we discuss a lot the elderly population and um, the brackets of society that are more digitally illiterate. So they are more prone to these problems. When it comes to children, we certainly face a major problem. Yes, I did mention the family in my presentation, and there's a very delicate and dangerous topic when the protected institution is the family. Sometimes I believe that this shows a lack of understanding about the child as a subject who has rights regardless of the family they're in. It's important to face this fact. Children are also vulnerable in their families. They are also in a risky position within their families. Of course, in our institutions, when we look at state, society, and family, these are the three institutions responsible for protecting children. But families are closer, and we have this culture that, attributes to family this responsibility. So there's the possibility of developing technologies. Some years ago, there was a lot of talk about IoT and the risks it represents for children. We consider that families are there as a filter to protect children. And I think this is a reason for concern. So we see this with a critical perspective. We really want to occupy space in this discussion in order to take these concerns and this perspective so that new technologies respect and protect vulnerable groups such as children. I hope I gave an appropriate answer to your challenging question. Well, thank you all very much. I really want to thank our panelists for your excellent presentations. So we are now going to break for lunch. We're going to have 1 hour break. We are going to a restaurant nearby. It's a recommendation of Professor Diogo. So we're going to walk there. It's called alcachofra. It means artichoke in Portuguese. But feel free to go wherever you want. So let's all be back here at 1:30. Okay, 1:30, we'll be back. Thank you. Good afternoon, everyone, and welcome back. Once again, I would like to thank the School of Law of the University of São Paulo for providing us with this room. Now we're going to talk about costs and externalities of the industry, public policies, and judicialization. I'm going to introduce our panelists as they make their presentations. I would like to start by thanking Adriana, who is legal director at ACT. Good afternoon, everyone. Thank you very much for the introduction, Davi. I'd like to salute Carolina and Vinicius, my colleague panelists. Congratulations on this initiative. I'd like to thank the O'Neill Institute and the GDPP, the Law and Public Policies Group. I am here representing ACT, an organization for health promotion. I have a slide presentation. SAT is an NGO. We have been active since 2006, first fighting for smoking control. And as the years went by, we included other topics that are risk factors for NCDs. So it's about control, smoking control or tobacco control, promoting healthy and appropriate diets, control of alcohol products, and also promoting physical exercise. All these activities are connected to the UN's SDGs. We bring together many advocacy organizations through evidence based public policies. We work in a network system. So we have many partnerships, and these are the two networks you see on screen. Well, NCDs, the main ones are cardiovascular diseases, diabetes, cancer, and they are responsible for about 70% of deaths in Brazil and in the world. And these are premature deaths, hence the importance of working with prevention. We have to focus on risk factors in order to avoid these precocious deaths. NCDs also contribute to severe COVID cases. So there's an overlap of global epidemics, which leads to the worsening of the social and economic damages caused by these factors. Considering the topic of today's events, I'm going to focus on ultra-processed foods as a risk factor for NCDs. But I'll be using some examples connected to tobacco as well. We can learn a lot from these examples. There are some success cases, and I'm going to talk about eating habits as well. There's recent data. This is a research that shows in Brazil we have 57,000 deaths a year due to the consumption of ultra-processed foods. This is a 2019 survey with people with ages between 30 and 69 years of age. So talking about epidemics and pandemics, we have the concept of a global syndemic. We look at the Lancet Commission's report. These are the joint pandemics of obesity, malnutrition, and climate change. They take place simultaneously, and one has an impact on the other. So this is a broader context when we talk about NCDs and eating habits. It helps us to understand the dimension of this problem. In Brazil, we have growing figures of obesity in between children and adolescents. We also see an overconsumption of sweetened drinks that makes this situation more severe. So these drinks contribute for this problem. They have added sugar or a sweetener, and they have low nutritional value, these sugary drinks. And consumption of these drinks is associated to cavities, type 2 diabetes, high blood pressure, and we have a website link on the invitation, and I invite you to visit this link. There's an online petition in favor of what we call health taxing. Well, sugary drinks, alcoholic drinks, pesticides, although they are not a risk factor for NCDs, they do lead to damage to consumers. But they also lead to negative externalities due to the negative consequences of their production, selling, and consumption. The master of negative externalities is my colleague here, Vinicius Fonseca. I would like to define or share this definition that's in his book. Externalities are the products of specific activities which are not included or considered in its production chain, and therefore in the production costs and its price. Externalities can be positive or negative. So creating a company can create jobs, but it can also pollute a river, for instance. The consumption of these damaging products, it leads to diseases among the population, and it increases the pressure on the public health system. There are other impacts we're going to cover. As for tobacco, this is a cost for treating diseases connected to tobacco and the loss of productivity. And even when a family member has to be a caregiver of the person who's sick, it's a cost of over 120 million reais a year. And here in the graph, you see all the amounts. So these are high amounts. They do not only impact the person or the individual, there's an impact in public finance and the economy of the country as a whole. As for sugary drinks, we have also negative externalities due to the treatment of related diseases. That's over 3 billion reais a year in treating NCDs connected to sugary drinks. That means 0.44% of everything Brazil invests a year in health. For tobacco, that expense is equivalent to 1% of the country's GDP. It's a lot of money when we think about our public health system that has such high demand and works with finite resources. Alcoholic drinks, here we have data, direct costs associated to treatment of diseases connected to alcohol. They represent a total of, the amount here is in dollars. That's over $8 million a year spent treating diseases connected to alcohol consumption. These are negative externalities that are resulting from a business. A company produces a product that leads to the negative externalities. They profit from this and they do not foot the bill. Society and the state, they foot this bill. So our proposal is that companies should internalize the negative externalities. They should cover these costs. We want society to have this debate. We want to broaden this debate. Otherwise, the cost will lie on the hands of society. So the SUS health system is in Brazil is universal. They spend treating these diseases, and that hinders other people from receiving necessary resources or services. What can we do in the face of these negative externalities connected to NCDs? Well, first, companies should internalize these costs. There is need for state intervention through public policies and policies focusing on consumption reduction. If you reduce consumption, you reduce the externalities. So that means advertisement restriction, labeling legislation, health warnings, regulations for the environment or regulating the school environment, restricting places where alcoholic beverages are sold, and also taxation. I'm going to talk a little bit more about taxation. Considering the Brazilian health system, public health system, the SUS, this should be covered either through taxation or through legal initiatives to provide compensation, civil compensation. And we can have both strategies. We will spend treating on these diseases. So the state will then levy taxes, and maybe the tax collection will not be enough to cover the expenses. And then the state can also file a lawsuit to demand for compensation, referring to the difference in the amounts. So taxes play an extra fiscal role, which is a way for the state to intervene in the economy. And it's also a form of public policy, either to foster or disencourage specific behaviors or movements. It's an attempt to interfere in taxpayers' behaviors. So if we want to make the access to damaging products more difficult, we increase taxes. There is an impact in final prices, and with that, we inhibit consumption. So taxation of damaging products, of course, increases tax collection, but there's also the goal of changing consumer habits. Taxing damaging products is also connected to the selectivity principle, focusing on what our Constitution states about taxation. So let's talk about health taxes now. This is a term that is nationally and internationally used, and it talks about taxation on damaging products to one's health. Here we're talking about tobacco, alcoholic beverages, ultra-processed foods, including sugary drinks, and also pesticides. Pesticides are not a risk factor for NCDs, but they should be included in the debate because in Brazil we have important tax benefits for pesticides. We face a problem in Brazil. There's no point in just increasing the taxes on sugary drinks. If you provide tax incentives for production, billions of dollars in tax incentives for the non-alcoholic drinks industry. So we need to work with taxation, and I'm going to talk more about this. If we increase taxes, we increase the final price. So we are actually limiting access to the product. But the goal is also to collect taxes, and then the state will invest the collected resources in health, in the health system, precisely to correct or to cover for these negative externalities caused by these products. So we have different contributions. We have the social contribution, and these allow us to target the investments. Health taxes are public policies that have the support of the WHO, of PAHO, the World Bank. So national and international communities support this type of taxation. For tobacco products, there's an international treaty that directly states that this type of taxation should be placed on tobacco products. As for the other products, we have other publications from different local and international bodies. Binding these resources or the use of these resources contributes to increase funding for public health, contributing for the country to reach the UN SDGs. So, in this debate, we should discuss a tax reform, but not just a tax reform. We can have bills imposing these taxes. There are some bills in Congress already. So we've taken this debate about a solidarity tax reform. It's what we call a 3S tax reform. I invite you all to access our website. There's more information there. So it's a proposal for a tax reform that reduces social inequalities, charges more from those who cause damage to health and the environment, and encourage those who contribute to well-being and social justice. This is an important publication in a partnership between ACT and PAHO. Brazil is a benchmark when it comes to public policies in that area. There's a study conducted by the FIPE Institute from the University of São Paulo. It's a simulation on health taxes. So the WHO says that the minimum taxation, the rate should be 20% up to 47%. And what is the impact of an increased taxation both in consumption and in the economy? And results show that people would migrate to healthier foods. Jobs would be created in different sectors of the economy. And then we conclude that taxing sugary drinks is good for the economy, for health, and for society. Another important publication, this is from an international task force that acknowledges the health benefits of taxing tobacco, higher taxes on tobacco, alcohol, and sugary drinks. As for social benefits, this problem has been acknowledged by the Brazilian IRS service. Data from 2018 shows that there were about 40 billion reais in tax incentives for this industry, not just in the Manaus production region, but throughout the whole production chain. And we have to be aware of this problem. Our administration needs funding for social benefits. So there's so many tax incentives that could be reviewed in order to cover for these needs that would be then targeted at social benefits. These are some campaigns we have. One is for soft drinks, looking at soft drinks. Because, usually people say, well, it's just more taxes. And here we want to show that this taxation is acknowledged by the World Bank. In the mid and long terms, this taxation actually benefits the population, the poor population actually, because they stop consuming or decrease the consumption of damaging products that can lead to health problems and even death. It's a 30-second video. I don't know if we can watch it. Okay, let's skip for the next slide. These are some other campaigns we run. There's a report from the World Bank. It talks about taxing consumption. And this report shows the progressive long-term benefits for health, reduced diseases, and families then spend less money with medication and health. And with that, I thank you. I hope I'm on time. Thank you very much.
I would like to thank Adriana for her presentation and also for her work in this area. It's great to look at projects like this and to see that negative externalities is something that at the end of the day will also affect the population. So it's really important for civil society to get organized and to demand what's necessary for the benefit of the population. And by the way, congratulations on the implementation, because negative externality sounds like something that's very complex. But when we talk to civilians, and they say, wow, I think that the company marketing these goods should be responsible for the damage. This is not as easy as it sounds. Okay, now let's turn it over to Carolina. She will talk, well, she is obtaining her PhD thesis from USP, and she also is a master in constitutional right from the Catholic University of São Paulo. She has worked in competition law and also at CADE, the antitrust agency. And currently she's a researcher on competition and also food environments in Brazil, a joint project between GDPP and O'Neill Institute. And she is now located in the O'Neill Institute in Washington, D.C. Thank you very much, Davi. First of all, I would like to thank you for this invitation to speak to this audience. So many qualified participants in the academic debate. I think that what I'm about to say has a connection with externalities, but I'll leave it up to Vinicius to discuss this part. And I will try to make a correlation with this and the defense of competition. So I'm here representing Beatriz Kira, Luisa Carmandaí, and Diogo, and also Felipe. They were all researchers in this project. So just to begin, here is some information on competition law, because it's not obvious that everyone has the same background information about it. So in Brazil, we have an authority that's called CADE, and it operates in three fronts. First of all, in repression of anti-competition bodies such as cartels, then preventive, in which they analyze possible deals, mergers, and acquisitions. For example, Sadia and Perdigão, and also other mergers we've heard about in the media. And another pillar is the education pillar, in which we teach our audiences the meaning of competition. For example, we used to have a cartoon that we gave to business people flying in the shuttle service between São Paulo and Rio. But today we're going to focus on prevention, because this has a closer connection to externalities, and also because in our empirical research, this is where we got the most results, because CAGI doesn't really look at conducts, as I'll try to explain later. So when we think of concentration of economic power, how can we analyze? So the antitrust agency, CAGI, usually takes a few steps when conducting an assessment. And we try to understand, well, if CADI is analyzing a health-related or food-related market, do they execute the same steps, or do they focus in some specific issues that are exclusive to this sector or industry? So here it goes. What they do, first of all, they try to understand the market that is at play. For example, if it's a replacement, if I'm talking about a telephone, a landline, does it compete with a mobile phone? Or can I take a landline wherever I go? If prices of my mobile phones go up, will I buy a landline instead? So these are the questions they tried to answer. In the case of Sadia and Perdigão, they were two major meat packers. And then they decided, well, there's not really much of a competition, and this is how they define what markets were affected. By defining the relevant market, they will also understand the market share of companies in that sector, and they can measure their power. If they hold, for example, 20% or 40% market share, what is the proportion and what is the impact of that operation in the market. After that, they'll try to understand if the resulting company will have enough power to act as a monopoly. So, for example, can they impose high prices, or will they have such purchasing power that they will cause an impact in verticalized markets or the supply chain? Or is the market going to be so concentrated after the merger that the effect will be similar to a cartels? So if I have only two competitors in this industry, maybe the only thing that I'll do will be erode the competition. If CADE concludes that this deal is detrimental to the market, they will try to find the antitrust efficiencies, countermeasures to the deal. And like this, they try to find possible solutions to the dilemma. And when we researched about this, what we realized is that for the food industry, those were exactly the steps. So whether it's tires or food, Kaji proceeds in the exact same way. Specifically on the topic of externalities, CADI measures in form H, which is a form for horizontal concentration. They look at externalities from a perspective of efficiency. So if the deal will um, will create negative externalities or positive externalities. This could be a consequence of the deal, but CADI makes it clear that in the analysis, if there are any public policies that will eliminate negative externalities, I won't consider this as specific to the merger or acquisition. Well, this is not very clear because in the matter of efficiency, CADI believes that, this is a complicated measure to weigh, but I thought it would be beneficial to mention this aspect. So now, in relation to the research and in relation to competition, externalities, the fact that CAGI does not take into account externalities if there is a mitigating public policy reflects what we found in the results. The deals analyzed by CADI are really restricted to the relevant markets. So once they define the market, they do not look at any surrounding or adjacent issues. We believe CADI should have a broader outlook to analyze the entire value chain. So first of all, they define the relevant market. After this, well, they will refer to the chain. For example, in the market of fertilizers, they talk about the supply chain or also in sugar exports, but it's just to set the backdrop. And when they start discussing the power in the market, then they're really focused on that specific market. They don't think sugar exports could impact, for example, sugarcane production or anything like that. We also observed that the analysis of power is also very limited to the market share that the company holds. They don't look at how power was built, developed, and held. It's really something that focuses on the relevant market. And the same is valid for food. I don't know if you can read this chart. It's a little bit of an eye chart, but we can see that based on the BRICS report that was developed And also, speaking to the professor who created this, he is currently the head of the Competition Defense Authority in Greece. So they created this chart explaining that the food value chain could be organized like this. Firstly, biotechnology and applied R&D. Another link in this chain would be production factors, then production itself, foreign trade, processing, retail, and finally the end consumer. Those are the links in the chain. And they believe that all of this should be taken into account. If you're speaking about supermarkets, are you going to look only at the number of checkouts or the number of stores? Is this what is going to be determining the power of this supermarket? For example, if Carrefour and I don't know, different supermarket chains are located in the same neighborhood, or should we look at the real impact of supermarkets in terms of pricing, pricing fixation, and also even production, because they set the rules for marketing those goods and products. And this is something that CADI doesn't look at. So we believe that it would be important to expand the reach of the assessments. So antitrust analysis should include the entire value chain of food to understand what is the real power involved. So, for example, if I am a supermarket chain, how did they get so powerful? Because was it because they bought more stores? And what is their impact on the other links of the chain? How do the agents interact? And well, for example, if we're talking about supermarkets, can they easily delist suppliers from the list? And does it mean that end consumers will not have access to those products? And instead of this, Kaji looks at the numbers, prices of products, and uh, a- and in that market, but it would be important to understand the chain and how the chain operates, not only the impact on the final price, but also how the impact could cascade down the chain. And by the way, Vinicius, this type of analysis, well, Kaji, in our vision, well, antitrust, I think it's better to use, for example, indirect effects. I'm not really sure whether this could be considered an externality, because we should look at both negative and positive indirect effects. But I was really trying to understand whether I should use externalities or another term, because this is the term we use in the antitrust world. So I'll leave it up to Vinicius to answer that question. Well, I didn't spend all of my time, but I would like to thank you and also the researchers and the antitrust group. It was great to lead the project. Thank you very much. Bye-bye. Thank you very much, Carolina. I think that there is a very close link between concentration of players in the market, because this will also have an impact on the damage caused. So I think that your remarks are very relevant. Perhaps some agencies, such as the antitrust agency, should expand their outlook and field of analysis, a focus of analysis. And going back to what Adriana said, we're still discussing a regulatory environment because we're talking about public health, disease. So ideally, we should focus on prevention in order to uh, discourage other behaviors and also create market regulation as a consequence. But sometimes this is not possible, and we have to judicialize some of our demands. So I would like to introduce Vinicius. Has a master's from Caxias do Sul University. Also, he uh, he studied public policy in Georgetown, and he also a prosecutor in the fourth region. Thank you. Thank you very much. Could you please act as a timekeeper because you're all so disciplined, and I want to stick to my time. I would like to thank the law group and public policies group at USP, Professor Diogo, and also O'Neill Institute in the figure of Professor Isabel, and to greet everyone who's watching online and in person here. Well, this is a case study focusing on tobacco, but based on what I have seen so far and the speeches delivered, this is also something that has a close connection with food environments, and this will become clearer as I speak. So just as an introduction, we'll talk about pollutants as payers, which is an environmental law principle. Uh, well, the research now states that this principle should also be applied to public health, and this is a topic that's relevant for civil liability because it's based on a lawsuit in which the two largest tobacco conglomerates were sued, and the compensation that was asked for was to be used in the costs of public health problems in the universal health care system. So like this, one of the topics that we saw among several others, this is of course a very rich lawsuit in terms of its applications, was the application of this pollutant pays principle. I think it's important to understand the tobacco chain. Tobacco growing in Brazil in the south is very relevant. This is data from 1819, amounting to 6 billion, and taxes collected amounting to 10 billion BRL. Something that's never said is that 80% of all Brazilian tobacco is exported. We're just behind China. We're the second largest in the world. And this will also create other effects. The tobacco industry in Brazil is oligopoly. We have British Tobacco, previously Souza Cruz, holding 78% of the market, and Philip Morris has a stake of 15%, and JTI a little above 1.3%. In Brazil, there is a big discussion on legal, illegal markets because we have some tobacco coming illegally from Paraguay and other countries, and there is a conviction that this represents over 50% of the consumption of cigarettes in Brazil. And more recent data, based on a study that was used by the Ministry of Justice in 2019, in which they analyzed whether it would be a good idea to lower taxes in tobacco, and then they decided it was not a good idea. And they estimated the illegal market between 38 and 57%. Just as an overview of the tobacco market, there are several researchers studying this. Smoking is the most important preventable cause of death in the world. And there is a number of 428 deaths a day in Brazil. And since the 60s, data has established a causal relationship between smoking and a number of diseases. And since the 80s, we also have evidence about the addiction power of nicotine.
So there's the story of the way how the tobacco industry established in the world, many documents that were revealed through litigation cases in the US. But I'm going to be focusing more on this principle of polluter payer. Um, and we're going to talk about an objective bias uh, strategy. So, for tobacco control in Brazil, we have our 1988 constitution. I'm not going to list all these regulations, it's just an illustration. The last bullet shows how our regulation works. We have command and control norms, and we have taxation norms as well. Between 1989, prevalence of smoking almost 35%, and in 2019 down to 12%. It might be even lower now. This graph illustrates this decrease. I know it's not really legible, but it clearly shows the trend. And all these points show different regulations that have been implemented. You see the prevalence decreasing. This has been studied, and it has proved that taxation works for tobacco consumption, to prevent tobacco consumption. However, if we look at a prevalence of 10%, it's still 20 million smokers in Brazil, at least, to say the least. It's a lot of people. So now let's talk about the polluter payer principle and negative externalities. This polluter payer principle is very much used in environmental law, but its background comes from economic science. It was coined by the OECD in 1972, and I'll read the principle quickly just to give you an idea. The principle used to affect the costs of prevention and control measures fosters the rational use of scarce environmental resources, and it's made to avoid distortions in international trade. It's called the polluter payer principle. It means that polluters have to pay the costs for the development of the above mentioned measures in order to assure that the environment is in an acceptable state. I'm not going to go into details, but it was restricted or limited concept. It did not aim at improving the environment. So the initial goal of the principle was to avoid distortions in the international trade. So if in one country you internalize and in other you don't, one will be paying more, the other will be paying less, and there's a lack of balance in international trade. But the principle developed, and it then gained a perspective focusing on environmental law. This is consecrated by our Constitution. We have to protect the environment. It's in our Constitution, and it's a duty of the state, and it's the duty of society. And this can be connected to public health as well, although this is not very well established. We don't have jurisprudence about it. And that's what I want to cover today. I would like to bring the environment and public health closer. So the principle developed by OECD, it is established in many international treaties, the EU Treaty, the Rio, the Declaration of 1992, and then many principles and many articles in the Brazilian Constitution. This is the core of our study. And that's how we can apply this to tobacco and probably can be applied to the protection of public health. What are the goals of this principle? Well, the polluter payer principle, looking at jurisprudence and other research, the polluter payer principle is mentioned always as a synonym of responsibility, the responsibility of the polluter. And this principle has three main roles: economic integration, so the original goal, so working for economic integration. And then we have prevention, redistribution, and redressing in order to avoid pollution if we look at environmental law. So to avoid pollution, we have command and control norms. We have taxes that come with these command and control norms in order to disencourage polluting activities. Then we have redistribution. There's a criticism to the polluter payer principle. Some people say that the name is not good. We're talking about pollution, it's in the name. So it's applied when there is pollution. But actually, no, it's not like that, exactly like that. So this is actually a goal that it takes place before pollution. You have increased taxes, which is aimed at redistribution. So in case of pollution, we already internalize the negative externalities and we disencourage such activities. Finally, the redressing. This is very well established in jurisprudence and in courts of appeals. So if you develop an economic activity and you apply these norms, command and control, they pay the taxes, they have the licenses, they pay the environmental taxation, which has a higher rate, but still they cause pollution. Pollution is a damage. They have they have to compensate for that pollution. So you cannot go back to the previous situation before the environmental damage. Usually this is not possible, but they have to financially compensate for that. That's when we have redressing. So for environmental law and in the jurisprudence, this is not up for debate. This is settled in the Supreme Court. And redressing is connected to what the General Counsel for the federal government is doing, or AGU. They say that redressing is useless because it's equal to responsibility. They say that this is just civil liability. But the Supreme Court understands that this is actually complementary to other goals. For tobacco, the first reading seems to make more sense. But when we talk about public health, we see the implementation of this polluter payer principle is beginning. So at the end of the line, there's this third goal. If externalities are not internalized and if there is damage, there is scientific evidence showing a causal connection between the two things, and therefore there is liability. So the polluter payer principle is made from these three goals and they add to each other. I'm sorry if I'm losing track of my train of thought, but I really want to send this message. This is really clear in AGU's claim for tobacco. Everyone knows that smoking is damaging to health. For many years, we are controlling tobacco in Brazil. We have taxation that should be improved or increased. But what is the goal of doing that? The Framework Convention on Tobacco Control shows that the goal is implementing more control policies. And responsibility or liability is unavoidable. It's in our Constitution. All of us are entitled to use the judiciary system and receive an answer. It establishes, legislation establishes the responsibility of those who develop damaging economic activities. So we need these protection measures. Regarding negative externalities, well, these are residual products of an activity that are not considered in its costs or prices. As Carolina asked me, I am sure that externalities, of course, they can be positive and negative, but they are undesired consequences. That's not the goal of that economic activity. They're just an effect, an impact. When we look at the markets, as you asked, it makes me wonder. We know from our experience that supermarkets, they intend to control suppliers. I'm not sure if this is an externality. They have the intention. They can limit competition. They can interfere in the sales of these products. So I cannot give you a complete answer to your question. But regarding negative externalities, we have two main trends for solutions. One is through state intervention, taxation, or subsidies, or for particular interventions, private interventions. We have command and control mechanisms and also legalization or judicialization. There's a book by Thomas Lambert in which he has a questionnaire. He brings a questionnaire to discover the best way to face externalities. But each case demands specific solutions and analysis. And I think that tobacco can be applied to the food industry in many cases. But we need more research in that sense. So let me just give you some data. Tobacco diseases related to tobacco and externalities. Specific state duties to promote health or to protect the environment, they do not exclude collective duties or the duty not to damage the environment or public health. These figures are not updated and they are underestimated. Damages caused by tobacco-related diseases mean 56 billion reais, both indirect and indirect. So this is an optimistic perspective. Taxation would then cover a third of these costs. And it seems clear that the externalities are not being internalized. I'm about to finish. Why the polluter-payer principle should be applied to public health. We work together, Davi and myself, and we are in constant conversation. And these conversations made it clear to me as I developed the research that this makes a lot of sense. Health is the first constitutional foundation for environmental norms and for constitutional norms about the environment were connected to health. The right to a healthy environment is foreseen in many constitutions, such as ours. Our 1988 Constitution states that the environment is an autonomous right, but it is connected to public health. Both are diffuse trans-individual interests. We have solidarity rights involved as well. All of us are responsible for the environment and for public health, not just on the government or the state, and it depends on all of us. These are fundamental rights and duties. But we need to know what the Supreme Court in our jurisprudence is stating. And they say that the health and the environment are interconnected. The Supreme Court says that the two things are connected. And they use two principles for environmental law, from environmental law to protect health. We have many decisions showing this connection. The Supreme Court makes it clear. So there's no reason why the polluter-payer principle should not be applied to public health. We can discuss whether this application would be autonomous, what is the legal norm that would support the application of this principle in public health, going beyond tobacco. So let me skip a couple of slides here. We use Article 927 from the Brazilian Civil Code. It talks about the theory of inherent risk in one activity. That could also be applied to the food industry. But again, I believe this still needs more research. Finally, this principle asks, who is the polluter that should be paying? Is it the smoker? So the polluter that has to pay, and when they pay, they allow for the conduction of the polluter payer principle. And what is the goal of the polluter payer principle? Is to protect the environment. So if you are subject to command and control rules, and if you are held accountable, you have to actually lead to changes in the real world or to stop the pollution. So for tobacco, we are speaking of the large corporations. And for the food sector as well, I believe that major multinationals control this market and they have to be held accountable for that. This work, this is my master's dissertation, and it was published. So, and this is available for those of you who are interested. So thank you very much for the opportunity. Thank you, Vinicius, very much. And it's interesting, this comparison between health. There's a connection between them. Oftentimes in environmental law, this is seen as a byproduct of the activity. But in public health, oftentimes we talk about tobacco and food, and we're talking about the product itself. The product itself is the externality. And it's really interesting to draw these parallels. And the comparison is easier in goods without social or nutritional value. There are many layers of complexity in an environment where there is a nutritional value, but there's also damage, where consumption does not go or does not reach a damaging level, but maybe a combination of products does. This is fertile ground for research and evolution, and I want to thank you very much. And I would like to thank all panelists also for your contributions. When we deal with negative externalities, there are many factors involved, and arguments add to each other. They collaborate. There's no silver bullet, but we need legal initiatives, regulatory initiatives, all of them with the same goal. I think we can open for questions now. I don't know if there are questions online or from the in-person audience. Good afternoon. My name is Alessandra. It's a question for Vinicius. When we use the idea of the polluter payer, focusing on health protection, could we maybe work previously when granting these licenses? So for soft drinks or tobacco, for instance, can we maybe look at the conditions to state that in these conditioning measures, there is a specific resource, or there are conditioned or binding resources for public health programs? Is that something that can be done? Is it feasible? Yes, it is feasible. And it talks about prevention. In the environmental area, this is quite well established. All the licenses we've studied, they cover that area. It's more about the political will of legislators. The academia also has to research on that. The academia can show this to public agents or legislators. I am currently health coordinator in a region in the south of Brazil where I come from, and we are facing a dilemma. We see tech advancements in medicine, and technology is more expensive. We cannot afford to do that. The state cannot handle, and health insurance plans cannot handle it, allowing for an increase in disease numbers in our population. Some studies should do this financial calculation. It happens with tobacco and it happens in the food industry. So numbers will be higher. And when you look at these figures, these financial figures, there's an impact. What is the cost of that? Diseases in the population, they have a cost. And the best way to work is preventive, as you mentioned. But I think it's about convincing society and decision-making agents of this importance. I was thinking about this possibility when you create a tax, a binding tax, what is collected when you sell cigarettes, part of this amount is a tax, and legislation has defined that this tax is binding and it will go for health. So legislation can define, well, this will go for the National Health Fund, or it can go for tobacco control programs, or it can be used for prevention. It can be defined in legislation. I know it's important to work with prevention, or we know it's important to work with prevention when it comes to smoking control. So you have a tax, and then the funds are connected to or are binding to prevention efforts. It can all be foreseen in the legislation when the tax is binding. I had asked specifically about that because the licensing organization has more freedom in establishing these conditions. So if there's a plant to produce tobacco, for instance, then legislators can foresee this. We can then use the polluter-payer logics. And in the conditions, there can be specific funding for the public health system. We can levy taxes that are not in legislation, but it's as if it's a compensation. They acknowledge the damage exists and they establish compensating measures. So there's a specific provision to fund a public health system or a public health program, for instance, maybe for the prevention of diabetes, something directly connected to that activity. It's easier than relying on the will of legislators.
Hello, good afternoon. I am Paula Jones, and I'm not a legal scholar, but But one of my areas of study is redressing costs related to smoking. And one of the things I ask myself, because I'm constantly speaking about this with Isabel, why don't we do the same with trans fat? We know about the harm. We know this is, something that cannot be challenged. And then you just spend centuries just discussing the regulation, and you start feeling a little impatient with the slow progress of public policies. And this is an additive that you cannot ban, unlike the cigarette. Trans trans fat is something that does not necessarily have to be included. You can find replacements for it. So there's a measurable cost associated with this, and this could be an action that will discourage food industry to add more additives that will be as harmful in the future. So, it's about objective liability here, I believe, and maybe we should set the example to prevent food makers to add more junk to our food. Unless if they know, well, if you add some killer ingredients to what you make, then maybe you have to pay for the damage, right? So I don't know, this some random ideas that I wanted to share with you. I think this is a very pertinent question. It's something that we discuss very often. We put our heads together trying to find solutions for this, and in fact we need to take some steps. So the definition of the defendant is something that's complex, because tobacco is something you have a target that you can to whom you can direct your claim more easily, because there are very few people who switch brands, so data on consumption is safer. So it seems to me that with food, you're lagging behind but it's also moving in that direction. There are some things that we are thinking about and solutions that we are devising, and some time ago this wasn't the case. So I share this anxiety with you. I wish things would move faster, but it's really important that we move cautiously, because a bad precedent could also be very detrimental. So, with tobacco, years and years of discussions went by until we found the legal grounds, when we then got the institutional support and the government support. So these are things that you have to address cautiously and responsibly. But we're moving forward and we'll get there. I don't know if with uh, trans fat or other ingredients, but we definitely have to go there. And by the way, tobacco is the implementation of Article 19 of the Fourth Framework Convention on Tobacco. So the Brazilian state made an international commitment. They accepted the terms associated with it, and they decided to file a claim against the tobacco industry. Other public agents could think otherwise. So if you're watching, the federal government implemented Article 19 of the Fourth Framework Convention, and several studies were conducted after that. So it's a maturing process, but somebody has to lead the way, whether the federal government or somebody else. Anybody else? No, I think that was it. I think we have a question. Good afternoon. I have a question, if I may. It's about the damage repair actions. We know how costly treatment for conditions associated with some foods or ingredients can be, but it's impossible to make companies liable for this type of harm. If we don't do that, how can you define the damages that those companies have to pay for? In the case of alcoholic beverages, some are more harmful than others because they have a higher GL. So how are you going to set this price? Thank you. This is a very good question and a question that we get often. Okay, let's start with the end in relation to alcohol. Well, this tobacco lawsuit was, well, we had something in our favor because there is no distinction between the products. They are just as harmful, in fact, or so we can use the same argument. This is a civil public action on a diffuse right. So we believe that everyone who finances the Brazilian public health system, that is everybody, could be considered as a claimant because they are all suffering the harm. So how can you quantify damages in a population-wide scale in a country as large as Brazil? You have to use statistics. So for the causal relationship, we use epidemiology data, which is exactly the type of science that is pertinent for that. And one of the applications of epidemiology, in fact, and this is, of course, how medicine evolves, is through statistical studies. And it establishes not only a cause effect relationship, and many times it fails to do that. Sometimes they say it's just an association, but sometimes they are very adamant about saying this is a cause-effect relationship. And we look at the population and determine in what percentage of the afflicted there is a cause-effect relationship. Just let me toss some numbers around. Let's imagine that the public health system uses 1 million reais a year to treat lung cancer. And epidemiology tells us that 90% of that fraction, in 90% of those numbers, there's a cause-effect relationship. So we take the 1 million and we are going to claim that those companies pay 90% of that 1 million. And this is something that is commonly used in the US in civil liability collective lawsuits. And we also take into account the market share. This is something we do considering, for example, the last 30 years or when Philip Morris entered the Brazilian market. So this is one of the defendants. I think they were the late comers into the Brazilian market. They only established operations here in 1975, and there are several studies that show us the market share of those companies. So it's very complex. It's based on statistics. And for example, cause-effect relationships on an individual plane are hard to prove. And even in the STJ uh, lawsuits or claims, they're usually denied by the STJ, but by using statistics, we can reach safe parameters. And it doesn't matter how many discussions we have with epidemiologists or statisticians, we can only underestimate the numbers because if there's a problem with the data, it's always an underestimation rather than an overestimation of costs. The only risk we run is that the data will fail to represent all the damage caused to society. Anybody else? Okay, my name is Leo. I have just one question in relation to taxation. My question is addressed to Professor Adriana. Well, I would like to know about the free trade zone for sugared drinks. So this tax break that the free trade zone does this affect the Manaus population also in relation to tax collection and enjoyment of the benefits of the taxes levied? Well, thank you, Miguel, for the question. This is quite complex, in fact. We could have a long conversation about the Manaus tax breaks. Well, there are some tax breaks because it's a free trade zone, and companies may apply and they get the tax exemptions. So companies make the concentrated extracts. Those are the inputs needed to make sugary drinks away from Manaus. So there is not a very high industrialization content. They sell ingredients separately, which also reduces the industrialization content. In terms of job creation, it's just negligible. I'm not sure if I can remember correctly, but if you look at I'm here with Maurilia and Paula. They are my friends from CET. So in terms of job creation for that industry and the size of the benefit, you see, how much each job costs. They're very costly jobs for the government, and it's completely uh, not in parity. So they sell these inputs in other cities, and the companies, and based on the Supreme Court decisions and the state, have the ability to offset what they have paid in IPI taxes. So, for example, I buy a product, and then in the next step, I uh, I can compensate or offset what I paid. I haven't even left Manaus, but I already get the offsetting of that cost, tax cost. So the higher the tax break, of course, the bigger the benefit. I'm not going to pay anything, and I'm even offsetting that. And this is something that trickles down the chain, and several other tax benefits occur. So this is a calculation that the Internal Revenue Service showed us of 4 billion in tax breaks a year, considering all production steps. And we're talking about harmful products where the final price to consumers is very low. Today, juices, you probably saw this, if you go to and get a glass of juice in a restaurant, it's much more expensive than a glass of Coke. And there are several irregularities involved as well. Products are misclassified, so it's really a mess. And the IRS is paying attention to this, but they have to fight a very strong lobby. So, in fact, if companies leave the free trade zone of Manaus, the population of uh, of Amazonas state will they really suffer because of loss of jobs or loss of income generated? Not really. Well, the only reason I'm asking is because I come from Manaus and I worked with the Suframa entity to analyze the impact of a change in the tax breaks in the taxes collected in the state of Amazonas. I hadn't thought really of how this taxation, and it's just like you said, if you go to a restaurant, the real orange juice or another type of juice is much more expensive than a soft drink. And speaking of the lobby, I was researching soft drink industry some time ago, and 70% of all of the soft drinks come from the Simões group. So there's a lot of concentration there. So thank you very much for your presentation. I think we'll close this panel now, shall we? Okay, so we'll be back at 3:30.
Good afternoon, everyone. So let me start by introducing myself. My name is Beatriz Cunha. I work for the Public Defender's Office in Rio de Janeiro, and I'm doing my master's in public law at the State University of Rio de Janeiro. I would like to thank the organizers of this event, the group for Law and Public Policies. I would like to thank Professor Diogo Coutinho, the University of São Paulo, and also the O'Neill Institute, Mr. Oscar Cabrera and Isabel Barbosa, dear friend who I see in the audience today. This is a very important event. It's really important to debate food policies in Brazil. And it's interesting that this event is taking place right now. 2 days ago, we received the news that the world's population has surpassed the mark of 8 billion people. It's quite a meaningful threshold, and it's cause for concern in civil society, the academia, and international organizations precisely because of hunger. The fact that we have this important growth of the population means challenges in order to ensure appropriate nutrition and the right to appropriate food for the population. Being aware of climate changes, forced migrations, and social inequalities we already have, most of all in the global south and here in Brazil as well. So, once again, congratulations to the organizers for this event. And the topic of this panel has a relation with what I've just said. It's about food policies and how we can ensure that these policies actually reach people at the end, the tables and the kitchens of our population. So, without further ado, I would like to give the floor to our speakers. It's an honor to be here together with three uh, amazing experts in nutrition. The first speaker is Professor Renato Maluf. He's going to talk about the evolution of nutritional safety in Brazil. He is a member of the CDPA, the Graduate Program for Social Sciences on Development from the Federal Rural University of Rio de Janeiro. He has a PhD in Oxford, a master's at the University of Campinas, and he's a researcher on nutritional safety. He's also part of the Observatory for Public Policies in Agriculture at the Rural University of Rio de Janeiro, where he is a professor. Besides this amazing CV, he has been nominated to be part of the transition team for the new administration. So he's going to be able to contribute to public policies on the food sector. You have the floor, Professor Renato, and thank you very much for being here. Good afternoon, everyone. Thank you very much for inviting me to be here. I would like to thank Diogo and Carolina who came to me, but I also see Isabel here in the room. I'm very happy to be here. This is the first time I am in this important building of the School of Law, St. Francis Building, São Francisco in Portuguese. And it was great to listen to the previous panel. I have a flaw. I have a degree in economy, actually. And the things that were mentioned here before, I had studied them in textbooks with a different language, of course. So I learned a lot from the previous panel. I was asked to talk about this topic here in Brazil, public policies. So I've divided my presentation into three parts. I'm going to talk about the Brazilian history or track record. I'm going to talk about the current context of a severe food insecurity and hunger. And I can talk about perspectives, fortunately, so we can see hope on the horizon. A couple of months ago, I might have to talk about deconstruction or destruction. I have a friend that every Monday he posts in our WhatsApp. Oh, this is great. We don't have another week without the fear of a re-election. Well, in any case, we need to recover. We need to look back at the Brazilian history to understand what's going on today and our possibilities. We come from a period in which I call democratic times. It started before 2003, but for what it's worth, the period is between 2003 and 2015. We must bear in mind that what we did in Brazil at this period was a process of social construction, which culminated with a political decision made by former President Lula in 2003 of having this topic as a priority. But we needed this previous construction. And I was part of this construction. I think this is a given, it's a fact. The success we've had as a country in this field depended on two things. First, political decisions. Nothing can be done without political will. And the second condition was the competence of civil society and even the political field of human rights and the right to food and nutrition, how they occupied these spaces in society. There was a multidisciplinary political view and lots of social participation. That's what led to this construction in Brazil. Then there were a combination of integrated policies. I usually go over time, so I'm going to try to skip some slides. And if I'm over time, you can please let me know. But there was an integrated set of policies. Hunger, um, food security, and poverty, they are multidimensional phenomena. And they require actions that take into account different dimensions involved. They require integrated initiatives. So this is not an obvious work. Whenever I'm at a university, which is my environment, I tell my colleagues that the difficulty in having a multidisciplinary government action is similar to what we face in universities. Those are similar challenges. So let's not say that the government is the only one to face these difficulties. We know that knowledge is power, and being multidisciplinary is sharing this power and this knowledge. We have to share funds, we have to share personnel, priorities. We have to stop fighting over the poor population who they belong to, quote unquote. This was a reasonably successful effort. We could have done more. There's a lot of talk about the Bolsa Familia income distribution program. I am an advocate for income transfer programs. But what's important was the creation of formal jobs, uh, valuing the minimum wage, the advancement in social rights in the labor world, supporting family farmers, cisterns in dry regions of our country. So it was actually an integrated package of solutions. There was no silver bullet. There's no such thing as silver bullets. There are integrated initiatives to fight multidisciplinary problems. Well, that ended in 2015, 2016, when authoritarianism began and the coup was in place. I use the term parliamentary coup from 2016. And yesterday I heard the term legal/parliamentary coup. Well, there was a coup, that's the fact. A coup that led to a political crisis on top of an economic crisis that was already taking place. And we went through a period of growing unemployment rates, uh, devaluation of the minimum wage, an attack on social rights. This aseptic language of informal work, it hides the fact that this is actually poorly paid, uncertain jobs, temporary jobs, or work, and limiting social participation. And day one of the current administration, the administration of this president, I refuse to state his name. On the first day of every administration, there's a decree, and in their first day, they shut down an important council and they stopped the activities of many, many councils. That's why I say these are authoritarian times of deconstruction. Many initiatives were interrupted, shut down, or gained new meaning. Uh, Giving them new meaning, giving new meaning for these programs and guiding them according to the administration's preferences is very severe. There was a lot of improvise in social policies with electoral purposes. Okay, this is the matter for another discussion. But the truth of the matter is that at no field, it can be the economy, social matters, law, culture. In all these topics, we must take Brazil's inequalities into account. They are many, they have different types and natures, they are deep inequalities that have an impact on all fields of our country. And these inequalities are systemic inequalities. They are rooted in our systems, and the food system is one of them. This was discussed in the previous panel with a different language, of course. So, this is one of the Brazilian paradoxes, presenting the country as a large producer and exporter of food to the world. This is not exactly true. But on the other hand, people are going hungry. And we have more and more hungry people. The figures are scary. I coordinated the Brazilian network on research on food security. I would like to tell that story, but we don't have time. It's a network that unites researchers from around Brazil. It was created based on CONSIA, the National Council. And we decided to investigate food insecurity. We were in the beginning of the pandemic, we knew the situation was going to get worse, and the Brazilian Institute for Statistics would not use the Brazilian scale for food insecurity because they had no resources. They had no funds. The last time they did this was in 2018. So I have the colleagues here who have actually created, they are responsible for validating the Cornell method. And SDA uses this every year. It's the Brazilian scale of food insecurity. It's an indicator of perception, the perception people have about the condition of their families. So it's a subjective indicator. It's not anthropometric. This is a different type of indicator, but this was created by epidemiologists. So this Brazilian scale, or EBIA, states that there are 3 different levels of food insecurity: light insecurity, or mild insecurity. So mild food insecurity is the first stage. That's when families start reacting to restrictions, and there is a compromise of the quality of what they eat. They start eating worse. And then we have a moderate food insecurity. That's when there's an impact on quantities. They start eating less. And then we have severe food insecurity, which means hunger. This survey is conducted 3 months before the interview, and at least one member of the family did not eat for one full day or skipped meals. So, this is people who actually are living with hunger or in a situation of hunger. There are degrees of food insecurity. If we bring together moderate and severe food insecurity, that's people who are going hungry or who are eating less than they should or would like to because they don't have enough access to food. That's um, the trend of the EBIA, this Brazilian scale. So this scale has been validated. I was afraid that this was not be considered a priority anymore, but we became an indicator used by the IBG, the Brazilian Institute of Statistics. And IBG measures this rate every 4 years. So between 2004 and 2013, 77% of families were in food security. That's when we left what we call the map of hunger, the FAO map of hunger. It's not the same indicator, but these were the main circumstances. There was a lot of celebration, but it was embarrassing to be in the map of hunger. You can celebrate when you leave it, but you have to be ashamed of ever having been part of this map. And we are in this map again, in the map of hunger. Next, measurements takes into account data from 2017, 2018. So between 2013 and 2018, that's when we had a shift in this trend. Worse than that, actually. Just within 5 years, we went back 15 years in time. So data from 2018 is almost equal to 2004. And here we see how easy it is to destruct something that was built over a period of 10 years. So in our investigation, which is called VigiSun, it collected data from 2020, and the second one is between November 21 and March 22. This was a research or a survey conducted by the Vox Populi Institute, funded by civil society organizations. That's what allowed us to make this investigation. From the first edition to the second one, we had a little bit more funding from these organizations, which allowed us to broaden the scope of our sample. 2,100 interviews in 2021, and then 12,000 interviews for the second investigation. And just recently, we launched new figures divided or split into states. As I was saying, the pandemic did have an impact in Brazil and in the world, but it was not the main cause. It worsened the problem. The problem was already there. With or without the pandemic, this problem would continue to exist because of the choices of people in power, choices made by people in power. And it's not, the problem was not the pandemic. The problem was not facing the pandemic. The pandemic caused damages around the world. Epidemiologists have shown that there were more deaths than necessary if we had faced the pandemic in a responsible manner. So the pandemic made the situation worse. And the irresponsible treatment by the federal government made the situation even worse. So we've reached 41% of households only in food security. The figures are terrible. They're horrifying. 125 million Brazilians suffer some degree of food insecurity. 33 million of those go hungry. If we add moderate food insecurity, it's about 60 million people in a food insecurity situation. Between the first and the second investigations we ran, in just 1 year, the number of people in severe food insecurity increased more than the whole population of the city of São Paulo. Actually, 2 times the population of the city of Rio de Janeiro. These are the two largest cities in Brazil, and it gives the idea of the size of this strategy. Here we see the division between urban and rural areas. I'm going to try to be brief, but if you are interested, and I hope you are, you can download the full report for the 2 years. What we did in this research, we gave a number and a face to people who go hungry. So we have these horrifying figures about hunger in Brazil. We were in an adverse situation, and actually no one except one person fought the consistency of the data. And this person is a person who was named to be president of the IPEA Institute. And he was even questioned by his employees. We dismantled his arguments. I'm not concerned about the theory or about the indicators. It's perverse. It's perverse to manipulate information when people are suffering. So as I was saying, hunger in Brazil, is there income involved? Yes, of course. People with lower incomes are more vulnerable. And there's also labor involved. There's a difference between formal and informal workers, of course. There is a gender, of course. Is my time up already? Oh boy, okay. I'm really going to rush now. Households led by women are more vulnerable. Households led by Black people are more vulnerable. Domiciles with children of up to 10 years of age. Households, even those that receive the Bolsa Familia program, are more vulnerable. I want to go straight to the perspectives, the future perspectives. So this is the percentage of people who had their meals. Lula keeps talking about 3 meals a day, and this is the percentage of people who skipped at least one meal. Okay, so this is important. Where are we right now? Well, we have perspectives ahead of us. Now, with this tight but important victory in recent elections, we must bear in mind the importance of this victory. It's enough to look at what those who lost are doing. And that allows us to understand the meaning of this victory. So there is the perspective of putting the country back on tracks again. The 2016 coup was an attempt to put Brazil back into traditional tracks, unequal, authoritarian, with concentration of land, concentration of income and wealth. Lula and Dilma's governments, they were not revolutionary. André Singer states that he calls it a weak reform. And even being weak, we managed to achieve those results. That's how the Brazilian elite works. Anyway, so they tried to put the country back on previous tracks, but we now have to go back forward, and the tracks going forward. Food is key in that effort. Just like food is key for any person's life and for the life of the planet, there was a lot of talk about the connection between the two things. We are going through a moment in which food, human health, climate, nature are completely interconnected. We cannot treat these things in isolation. They are all subject of systems or systemic dynamics, and food systems lie at the heart of the discussion. There's a debate on justice. I don't think we have time for this today. We are incorporating two ideas. That one is food justice, and we can talk about this later. A quick interpretation is that food justice means social justice through food. And the other concept is food equality. So these are two important and strong references. The main challenge from my perspective is to combine emergency with medium to long-term initiatives. Of course, the incoming administration has to deal with hunger immediately. It's an urgent matter. And these mechanisms can be perfected. We know that income transfer programs are helpful. But these mechanisms have to be perfected in a combination of this emergency and also looking at long-term initiatives. That's the challenge. How do we face access to food, promoting what we call real food? That's the name we use, real food. How do we do that? Well, I talked about structuring elements. At the heart of the discussion, we have food systems. And I ask you, please ask me a question so that I have a couple more minutes. My research group is working on this, the transition of food systems. Last but not least, this is about political process, but also about values. None of that will happen if we cannot build a pact, or however you want to name this. We need to bring different players, and we need a process of shared values, starting with the value of democracy. The Brazilian experience is the result of the redemocratization of our country. There's this movement for ethics and politics, and then we have actions against hunger. This is all the result of democracy, and we depend on democracy to have this. So democracy is one of these shared values, this idea of citizenship. These problems are the result of denying citizenship, denying rights. I don't like when people say that people who are hungry cannot work. People who are going hungry, they're hungry. It's a human right. It just cannot happen. It doesn't matter the circumstances they're in. A human being cannot go hungry, period. And we need the appropriate mechanisms to fight this. And in the Q&A session, you'll give me more time to talk about our network and our research and etc. Thank you very much.
Sorry about that. Renato, thank you so much. Such important considerations. And if we get no questions from the audience, well, I have a list here, but I'll save them for later. In your work, the numbers really tell a story. Unfortunately, today we have denials taking place not only in health, but also in relation to data produced by our statistics bureaus. So it's very important that we don't deny the existence of hunger when looking at the data. And something I would like to hear from you later is about the challenges, considering the positive outlook. But at the same time, we have several aspects or several groups in society that are resisting and that speak about fiscal responsibility. So there are different opinions clashing. Everybody's saying that we should submit to the spending cap, but at the same time, there is a food shortage, not enough food for many people in our country. So how the two aspects interact, just as food for thought and also as fuel for our debate. Now we'll hear Valeria Buriti from FIAN. She has a master's from the Federal University of Paraíba. She's a human rights activist in the area of food security and access to adequate nutrition, and she's also a coordinator at FIAN Brazil. Thank you very much, Valeria, for accepting our invitation. And besides that, she is a partner of the Public Defender's Office in Rio. Thank you very much, Beatriz. I thank you for this invitation. The group of public policies, Diogo, Mariana, Carolina, and also the new institute, Natasha, etc. It's very important to be here. We learn a lot when we discuss food environments because our agenda has always been linked to sovereignty. But I think that in fact there is an interconnection. So we used to discuss sovereignty, and then we realize how ultra processed foods reinforce inequalities in our country. And it's very important that we discuss how choices are made. Well, I was going to talk about the dismantling of public policies. This is what we had agreed on, but I would like to start by a discussion of some key concepts. Then I will talk a little bit about our background and track record in public policy making related to food in Brazil. We'll give you some examples of the dismantling process and the demise of our public policies. Well, since 2017, we have been writing reports on human nutrition and access to food, and we have been taking note of the different setbacks and retrocess in that regard. Well, here we see different approaches to the right to food, but it's important to know that food is also a process. When somebody's obese or when somebody's going hungry, there's a process behind that where human rights are violated. So obtaining food, whether through planting or fishing, or I think that most of the people here go grocery shopping or go shopping in a trade market but fishing in some communities is a way of obtaining food. So for these groups, speaking about food without mentioning land ownership is just impossible. Also access to income, access to work, this is all very important, as well as the way food is ingested. So it's really important that the resilience occurs not only within our groups, but also for the benefit of the planet. In several of those areas, we see power relations, social relations, culture, also how the judiciary and the executive interact with the different steps. For example, taxation is one of them, and how labor is distributed. So is indeed a very complex theme. In Brazil, we have food safety and security to speak about. Well, in the international sphere, they don't really talk about nutritional uh, security. They just talk about access to food, no matter what type of food. But in Brazil, the process was different. When we talk about nutritional and food security, it's important to know how food is being produced, at what quality level, and the impact that food production has on nature, and also how food is distributed. So it's a complete process. And there is a strong link with sovereignty, which is this idea of the people not being at the mercy of the market. They can also create or plant what they want to eat. So these are very important concepts. And starting in 2003, we, based on these concepts, started developing a food and nutrition security process, or rather policy. Well, Ana Penano, well, she was a very important researcher, now deceased. She died about a year ago. And she said that food security was orchestrated in 4 acts. So when we start talking about food security in Brazil, we had Josué de Castro, uh, early on in the 30s and 40s, was asking this question: what is agriculture for? Is it to ensure we have good health or to ensure profit? So this is the underlying question in his book, The Dilemma Between Bread and Steel. And in the 1930s, José de Castro was already framing this question. So our policies started in the 1940s. We had some ministries such as health ministry and welfare and labor, as well as some institutions that had been set up, such as nutrition and food institute dedicated, started to look at the issue of food. Between 1976 and the 90s, some advances occurred. The second program on nutrition and food started talking about the importance of agriculture for the local supply. And there was also the challenge of the fact that Brazilian agriculture production was geared to exports. However, at the time, Brazil did not have sufficient strength to keep the maintain or to keep this debate alive. So there was a first conference on food and nutrition, but we lacked the strength to implement policies and also to enforce our food access sovereignty. So then in 2003, there was a turnaround with a lot of progress, but at the same time, some setbacks. The movement ethics in politics began. The hunger map was made, showing where the households are, and it was based also on the basket of stables methodology. So the hunger map was extremely important because it showed how hunger is a matter of social justice. Then the National Council was created, and hunger then actually moved in priority, moved down in priority, and then it was uh, food that began to get a lot of attention. People said, well, we see that a lot of people are going hungry, and we see that the current model of production based on large production units is something that simply doesn't work. So in 2003, as I said, according to her, this was the fourth act. And then a movement began. This is what, and when we refer to dismantling, we had a president that put food and nutrition security at the center of the political agenda. And this uh, helped us create a national framework and also policies oriented for foods and nutrition security. So this is the regulation. The constitutional amendment of number 64 added food security to the Constitution in 2010. We also have the organic law of food and nutrition security, and we also had several laws that established programs such as food security, for example, the school meals program, and several other ordinances and decrees. So the policies were complex and shaped the initiatives in this area. For example, access to food and also the link between food and nutrition is a guideline. Water is also another guideline. Supply and sustainable food systems based on agroecology is another basis. Support to traditional communities and all of those guidelines should also be informed by international policies. So a system was built in which there were a few components. A conference was held every 4 years in which about 1,000 attendees discussed the major lines of food policies. There were bi-monthly meetings of the council, Conseil, and there was an interministerial chamber congregating 19 ministries to discuss the demands arising from the council, and they developed the nutrition and food security plan that was later adopted by municipalities and states. So we had vehicles for participation, such as the conference and CONSIA. We had a intersectorial, it was an intersectorial approach. And in 2012 to 2017, we had approximately 96 billion reais in our budget. Of course, this was just funds earmarked uh, in 2018. So through all of our efforts, we were able to leave hunger behind, and several other results were very important. Family agriculture was strengthened. The reduction of malnutrition in children was another advance. And I think it's important to speak about why everything was undone so quickly. Why was this demise so quick? When we said, well, we've left the the hunger map, there were still some people going hungry. This is a graph showing height deficits in children. And when we're talking about, the correlation between age and height, this indicates the people who went hungry in different stages of their lives. And in 2000, well, there was a gap of around 10% in the national average, and we can subtract the deficit for the indigenous peoples, slave descendant communities, and other groups that are more vulnerable, where the gap was much larger than specific groups. So hunger never really went away. And this is an important reflection. Hunger should also be always be at the center of what we do. So why so fast? When we talk about the dismantling of public policies, just in very broad strokes, we're talking about, first of all, this is no longer a centerpiece in policymaking. We had learned in 2003 that this agenda is essential to secure rights for in several occasions, the president of the republic denied that there was hunger in Brazil. The minister of the economy said, well, Brazil has so many mango trees, nobody goes really hungry here. And during the pandemic, this dilemma was presented. Are we going to really preserve people's health or let them go hungry? Those were the issues discussed by the executive. So there was there was even an erosion of the concept of hunger. When the president says that hunger means, you know, a body that's shrinking, this is something that completely erodes the idea, because there are some people who are fat and still going hungry. And also the influence of agribusiness. This is a totally different type of agriculture. So several rules, Lausanne was modified, the Conseil, the council was extinguished. Even though it continued to exist in states, the council was the core with its ability to articulate actions among states and municipalities. The Ministry of Agrarian Development was also extinguished. There was a direct attack to food security policies with budget cuts or weakening and undermining of its effects, and other public policies with very negative impacts, such as the labor reform. um, Jobs became more precarious, and this was detrimental to the population, and also the welfare reform, the reduction in real terms of the minimum wage, and also macroeconomic policies. As for our fiscal policy, well, this is one of the key reasons for rights violations. A conservative vision was adopted where the state is like a housewife that can only spend as much as she gets. But the state is not really like a family. So the duty to have a spending freeze through the spending cap created a situation that was very unfair. I think that Adriana has talked about, for example, sugary drinks and also agrochemicals. So this they got a lot of tax breaks. So this accentuated human rights violations. What about budget cuts then? Well, the income transfer program was maintained, but other programs such as food procurement, in which food is purchased from family farmers, it had some major budget cuts. Also, cisterns, if you know Barreiro, this is how people uh, saved water, and they know in that region, in the semi-arid, how important it is to have water reservoirs. So several groups were affected.
Family farming is really important. Important for food supplies. What we eat comes mostly from family farming, and now we are losing ground to soybeans, space that could be used for rice and beans, some spaces that were targeted at family farming, then the extinction of the ministry. So there was a structure that was created, which was then extinguished. A program was preserved, but just recently there was a veto to an increase in the per capita amount for this program and a reduction of almost 18% of the budget of the PNAE, the Program for School Meals. During the pandemic, policies to support family farming were vetoed. We have a program that was called Alimenta Brasil, but it had no funding whatsoever. As Renato and Adriana mentioned, we cannot think about producing food without considering the environmental collapse. This is a concern we must have right now. So, starting with the Temer administration, the surveillance and the management of environmental policies became very fragile. So, forestry management left the Ministry of the Environment and went into the Ministry of Agriculture. It makes no sense whatsoever. There was a legal framework about land organization or land regulation, an agrarian reform legislation that allowed to sell public land at values below the market. Many initiatives that had direct impact on indigenous peoples. Violent comments from the president encouraging conflict in these indigenous lands. Protection bodies that were emptied, and pressures to flexibilize the protection of indigenous lands. There was a huge amount of approvals of pesticides. This is a new way of colonization. In Brazil, we consume pesticides that are forbidden in Europe. So we are a huge market for huge industries of pesticides. And here we see the acceleration of the registration of pesticides in Brazil. Since 2016, have been breaking record after record. When we thought we had peaked in terms of the use of poison, we went further. Also, in terms of public inventory, that's a way for the state to control the price of food, and it went down the drain. The red lines are public inventory, the blue bars are exports, and this is for rice. We have million tons in the vertical axis. So inventories are constantly decreasing, and the focus is only on exports. So when there's an inflation of food prices, an increase over 60% in the prices of staples such as rice and beans. I don't even have to cover ultra processed foods because Ana Paula talked about them. So that's it. We talked about the destruction, but finally we are now facing a new scenario. So it's important to think of our priorities right now. Um, Renato is coordinating the transition group for social development and for fighting hunger. So it's important to now listen to proposals about this topic. Thank you. Thank you very much, Valeria. Yes, you mentioned several important aspects in your presentation. What draws my attention is how fighting hunger cannot be done through one single individual public policy or just isolated income transfer programs. We need a set of public policies that will tackle several different branches of government to really lead to a transformation. At the end of the day, the current scenario results from two main causes you mentioned. First, the adoption of austerity policies. All the policies you mentioned, all policies that were extinguished or destroyed, they are connected to austerity, fiscal austerity. And the second is the lack of coordination. The PNAE example, or the program from school meals, is an example of that. During the pandemic, we had funds being transferred every month to states and cities, but food did not reach people's homes. You mentioned something really important. Of course, we are through this now and we have to look forward. There's a new perspective ahead of us. But what can we learn after what we lived? It cannot be repeated in the future. So we need to institutionalize some aspects so that they become permanent and stable, so that these policies become stable. We need institutional protection so that this situation is not repeated in the future. So now it's an honor to give the floor to Mariana Levy. She is a member of the Law and Public Policies Group from the School of Law at the University of São Paulo. She's also a professor at the University of Brasilia. She's a lawyer, a social scientist. She has a master's in law from the Catholic University of Rio de Janeiro. Mariana, you have the floor. Thank you very much for being here. And we are very happy to have you here with us. Thank you, Beatriz. Good afternoon, everyone. It's a pleasure to be here today. First of all, I would like to thank the O'Neill Institute. I would like to thank Isabel and Natasha, who have been doing this research with us in recent years. And today, I thank them for helping us to organize this seminar. And I would like to say that it's an honor to be part of this panel. The, the Public Prosecutor's Office in Rio de Janeiro, Beatriz, is a benchmark. It's a national reference when it comes to research in the field of law. Our group, the GDPP, we admire the work you do at the Public Defender's Office in Rio because also of the research activities you conduct. So congratulations on your work. It's a pleasure to be here sharing this panel with two amazing experts in the field of the right to food and nutrition. Valeria and Renato, they are dedicating their lives to this right, and they also have an important legislative contribution. The right to food is in Article 6, thanks to the work of these two people. So, thank you very much for being here. It's an honor to share this panel with you. For those of you who don't know, in our group of law and public policies, we have 19 researchers from different fields in law, technology, competition. I have always studied land regulation, both in urban and rural areas. And now we are working together, facing the challenge of studying the right to food. So I'd like to thank you for your generosity and for decades of work. Ana Paula was here this morning, and we were fortunate to have her with us, but also grassroots and civil society organizations, ACT, ACT, IDAC, and many researchers who have been helping us. So today I will speak about one of the areas of research we've conducted in recent years. Our group has divided into three main pillars. So one is about competition and antitrust. There's a pillar about regulation, and this is the pillar focusing on public policies and the right to food. This work has been or is being published in the magazine that we are launching today, the Magazine of Institutional Studies. We're going to have a cocktail after we finish here to celebrate the launch of this number of our magazine. So we've discussed this in our group, and these are the authors of this text. Professor Diogo Coutinho leading this team of researchers. He's here with us. We have Maria Carolina Foss, Pedro de Paula, he's here with us. Carolina was here this morning and she's watching us online right now. So thank you all very much. And feel free to add or contribute to this conversation. So the goal of this article is to give our contribution with a legal perspective on Brazil's public policies. We decided to study the PNAE, which is the National Program for Meals in Schools. PNAE is the acronym in Portuguese. And the challenges to reach this right and looking at the rules for government purchasing. So there's a common backdrop in our group, regardless of our areas of research. The idea is to analyze the role of the state and to understand how different bodies, different programs and policies, and even state agents, how do they uh, interfere in the implementation of public policies in different areas. In this article, our goal is to understand what is the role of law in structuring the National Program for Meals in Schools, the PNAE. We look at the impact of the program itself, and we also look at its impact in the food industry or the food market. We want to understand how the market works or competition rules, how a program of this size can have an influence. So in the case of Panay, throughout the decades, we see an exponential increase in food suppliers to school meals. And this is very much connected with civil society throughout the decades, but this is also an attempt at understanding how the state and how government procurement rules contribute to that. So here we have a connection with government purchasing as a tool for innovation. Usually we think of innovation connected in connection with technology. So this idea of state actions that lead to changes, whether that's in space research or electric vehicles or buses. We recently saw an effort for innovation in this rush for vaccines during the pandemic. But when law or when the state have the intention of innovating, it's important to ensure flexibility. And oftentimes, legal rules do not allow for flexibility. So when we talk about innovation, the challenge is to think about the role of law and acknowledge the need for flexibility. This is not a technological change. It's a change in the field of public management focused on innovation. And when we want to innovate in terms of public policies, we need to flexibilize some rules. I know it sounds like a paradox. So we analyze how this takes place in the realm of school meals. Many countries in the world, as well as Brazil, use government purchases as a tool for innovation. Here in Brazil and in other Latin American countries, in the US and in South Africa, we see the use of this tool to ensure appropriate food or nutrition, whether that's reducing ultra-processed foods in schools or ensuring access to healthy foods. And again, there are consequences of public purchases. They bring about change in public management. And this is not just about school policies or educational policies. This is a program that has direct or indirect impact in different areas, whether that's health, education, culture, food, recognizing the food diversity in our country, land reform, the environment, and of course, food security. So using government procurement as a tool for innovation is associated um, to state programs. And when the state acts through government procurements, they can strengthen and they can, or it can encourage some specific markets. The PNAE, this program for meals in schools, is one of the largest government purchasing programs for food in the world. In Brazil, it's 40 million students. But we've studied a specific rule in PNAE and a specific moment. We were just discussing the construction of the legislation, then the destruction of the legislation, and I hope that we can rebuild this legislation. I'm very happy to know that Renato is part of the transition group into the new administration. But we decided to look at a very simple rule, a rule that looks from a legal perspective. There's a requirement that 30% of foods for school meals are produced by family farmers or indigenous peoples or quilombola people. So that's a duty of the state for government procurement purposes. It's not just about opening a bidding, a request for proposals and a bidding process. And it's not just about choosing the cheapest price. Part of government procurement should ensure purchases from family farmers, from indigenous and quilombola peoples. For those who have implemented this rule, you know it's not easy to implement. The idea is that we need to acknowledge different ways to produce food, ways of producing food that are healthier, that make more sense to children and adolescents. Brazil is a country of continental dimensions. We have 300 indigenous peoples in Brazil. So we need to acknowledge the diversity of our food production and of our food consumption when we create diets. The rules we've studied, that's when we move away from the general rule, which is the public bidding rule. There is a legislation for that in Brazil. And this mechanism brought an important consequence for public policies and for the market. I feel embarrassed about talking about this legislation here in this panel. But in any case, the PNAE was created in the 50s during the military, or before the military regime. There were very few food suppliers for Brazilian schools at the time. So in our research, we started looking at the right to food and nutrition, and we decided to do a literature review to begin with. And by looking at documents, legislations, and bills, we've noticed that during the authoritarian regime in Brazil, there was a lot of concentration in the market, formation of cartels, of suppliers. And then we had the 1988 Constitution that intended at decentralizing public policies. And there was a split of competences. It created a new structure in the implementation of meals in schools policies, but this also had an impact in urban policies. So the cities were part of the game. Now they were active in providing meals and creating the menus and establishing the diets in schools. So that actually increased the participation of cities and states. Then we have the creation of the Conselho board, or the council. This is a history that has already been covered in previous presentations. Well, in the 2000s, what draws our attention from a legal perspective is asking what was the rule that led to so many positive consequences to the quality of meals in schools? Why is PNAE an international reference? So, not only the need for these 30% purchasing was established, but there's a simplified purchasing procedure. There was a public call for proposals, but this was in dialogue with the way the foods are produced by family farmers and traditional communities. We've mentioned indigenous peoples, but there are also fishermen communities and many communities that produce healthy foods in Brazil. So there's an ongoing challenge, of course. There's still a lot to be done, but health legislation and our bidding process legislation, they need to think about different ways of producing food in Brazil. And we need to ensure diversity, whether that's through through the flexibilization of some rules that are designed for major corporations, which are very different from the Brazilian reality. So we looked at the legislation and we compared it to the legislation for bidding processes. We have legislation 866 and we have legislation 14122, which has some similar rules, but it excludes a letter of invitation. But the rules for perishable food, they were preserved. So in spite of all these attacks we've heard about today, there are many bills now in the Brazilian Congress. The executive branch has presented many vetoes regarding the funds to purchase school meals. And results are quite positive. The incorporation of cities in this policy was positive. When we compare the 90s to 2014, as you see on the screen, now more than 5,000 cities are part of the PNAE program. But we have not reached the figure of 30%. However, the progress is clear. 22% of food comes from family farming, or came in 2017. And here we see the number of suppliers. 200,000 small farmers were inserted in this program and now supply food for this program. So we're going to have time to discuss this. There is a reduction of funding and the amounts of PNAE have to be updated. This is an obstacle. I would like to thank the researchers from the Josué de Castro department at the University of São Paulo. Professor Ana Paula talked about the achievements that we've had in recent resolutions. So ultra-processed foods are forbidden now in schools, but we have many challenges ahead of us connected to the ability of cities to ensure an appropriate diet, even the physical space to produce healthier meals in Brazilian schools. So that's our research. The article has been published and it's available online. So we have time for a couple of questions now. Thank you very much.
Thank you very much, Mariana. Great presentation. And I would like to reiterate that that article is definitely worth reading. It's just fantastic. I came on my way over from the airport, and you touch on something that's so important and barely touched by anybody. How the school meals policy adopted in the country produce effects that go beyond children nutrition. So when we talk about the school meals program, how, well, people talk about how positive it is for children. Many times is their only meal in the day. But in your paper, you see that it extends beyond that. It's a way of developing family-based communities. And thank you very much for your presentation. Well, we have some moments, so I would like to open for questions, not only questions from the audience, but also from our head panel. If you would like to ask any questions to each other, or if you have final remarks that you would like to share. Okay, could you please come over? Okay. I think I'll ask a question to Renata. Maybe maybe not exactly what you wanted to add to the presentation, but it has to do with the late part of your presentation in which you were talking about our outlook. So I would like to know more about the experience that you're involved in as part of the transition team for the new administration. Mm, Can you give us a little preview? No, no, no. Just maybe an easier question. Well, what about a resumption of activities at the council? Is it something that we can expect? And by the way, I didn't introduce myself. I am Igor. I am one of the heads of IDEC, the Consumer Protection Institute, and I'm here at your service. Yes, yes, a member of the current management and also the future management. So we are very anxious to hear about this because this has always been a fundamental forum for all organizations. There we had an opportunity to act proactively and contribute to public policy making, especially considering what Ana Paula Bortoletta said this morning. Well, she was here this morning and she talked about food labeling, an initiative that she led in our organization. And as she said, well, the regulation didn't turn out to be exactly what we wanted. It was beneath our expectations. And while the council was active, this was a great space in which we could strengthen the network of organizations that work around this topic. Thank you. But what can we expect is my question in relation to the council. Okay, let's go. So how does the transition take place? Not working groups are created the same, but this working group has social development and fighting hunger as its axis. Maybe this will be the name of the new ministry. So the working group will create a proposal and submit it to the powers that be. The working group has a collegiate coordinatorship that will give you a dimension of we have two ministers, Mrs. Campelo and Marcelo Lopes. We have the Senator Simone Tebet, Bela Gil, André Quintão, a congressman from Minas State, and a Japanese. Well, he said his name. It's Ricardo. I don't know, Japanese surname, from MDB, and myself. 7 members. We are going to invite volunteers. We have no money, no funding, by the way. We cannot travel to Brasilia, and this does not displease me, in fact, because I like to, I don't know, to be where I am, but we can always have some remote meetings. But we're going to mobilize people, and when you talk about, state capacity, the role of civil servants in preserving values in this country, this is just outstanding. I am a civil servant, like many of you. I know what the role of federal and state universities is in this preservation of values. And I have received at least 2 messages from civil servant associations volunteering to help. And this is a very beautiful attitude. People are bent on rebuilding everything that we lost. So we're going to prepare this proposal and submit it by the 30th, and then we'll have a final report that's going to be filed by December 12th with proposed programs, etc. It's going to be intense. Maybe we won't be able to go into the details, but speaking from the point of view of civil society, I'm there representing the network Sun and the conference. I talked about the conference, didn't I? Yes, we had a national conference. So when the president closed the Conselho and banned conferences, we said, well, let's have one online. And this is a very broad group, it's just like Conselho, in fact. So I represent the network, the Brazilian Forum, and the 2 chairs of the Conselho. We have now, it's an entity. We have 4 former chairs, myself, Marichico, and Beta Rossi. So this is my role. And I am calling a meeting tomorrow morning with representatives from those fields. I have no idea how I'm going to manage this because everybody wants to participate. Everybody's feeling anxious, which is understandable. But first of all, we're going to collect some suggestions. I think there are some signs, but I think I'm not breaching secrecy by saying that it's almost certain that the Conselho will be reestablished and it will go back to being what it always should be. So it's very likely. I'm not speaking on behalf of anyone, not on behalf of the president-elect, but this is a matter of the highest relevance that the government wants. And yesterday, this is what he said. He wants to put hunger at the center of the agenda. So it's not only about having the Conselho in place, it's about managing it and having it operate. I think we've learned a great deal from that. We can always increase or enhance our representativeness, and the choice of members is important. There is also an issue around the nature of the council. I am an advocate of the consulting nature of the council. I don't believe that it should deliberate, or because if you want to be intersectorial, who's saying that I'm more representative than the health council? Just because I'm a professor and I wrote a paper or whatever? No. So we want to say our views about several issues: health, land reform, etc. And they have their own deliberative bodies. So we want a council with 2/3 of civil society, what we have, and with a chair from civil society. So why Why do we need elections? Because the program of government is defined there. I'll be the chair, and people will make decisions. The people will make decisions. So this is forgetting what politics is like. Politics, if we want politics with a capital P, so you have to raise awareness, and then you have to gain the hearts and minds, you have to talk to the president, etc. This is what I hope that will happen, and that CONSEA can be reinstituted. And something that's key, CONSEA used to make some very high quality diagnostic documents. The documents were very they were very well substantiated. So for me, this is the role, visibility. Some people say, "Wow, CONSEA is a fragile." Just look at the overall opinion about CONSEA's papers, and the only reason why CONSEA was so visible is that I had the power to call on meetings but not to deliberate, and we want to change this. In fact, we are putting pressure because we had the CONSEA with the secretariat and an interministerial chamber with the government agency, with a gathering of 20 ministries of more to collect suggestions, and then the government would accept them or not, which was the government's decisions. And we want to take a secretary, a special secretary of interministerial articulation, because ministers don't call ministerial meetings, but presidents do. So if we want greater involvement of ministers, then it's the president who should call the meeting. This is funny because we come from the academic sector. I would sign some some documents with the president's seal. So in the liturgy, you speak to the president of the republic. In fact, I didn't, but sometimes we had meetings with him. But in the org chart, myself, Maria Emilia, etc., we reported to the president, and this is very special. We don't really like to follow the ground rules, but this is the role we advocate. My opinion, which of course is arguable, I think that the Brazilian experience has not come to an end. It's not exhausted, even though there is much to be improved. Why am I saying this? Because recently we heard about creating the food ministry, and I am not in favor of that. And the same thing for Mesa. I was against it, but and they created it, and it didn't last for 1 year. And I think this is the way to go. Now, today, we have 2 months to build something that will be the product of a broad alliance. Well, in my working group, we have a former presidential candidate. She's, somebody with her own convictions. So we cannot beat around the bush much. We can choose, we have to choose what is essential, what has to be, institutional, and then we will iron out the details later. And the National School Meals Program has something that's urgent, which is the readjustment, because this is just like the Bolsa Familia income transfer program. I think that you've all said it. The school meals play a central role. It's in many families the only meal of the day. So we're looking at the priorities: a better Bolsa Familia, better executed with significant amount, the CONSEA, and then we'll rethink the ministry structure that I believe that has to be recreated. If we decide, well, this is not the way to go, this will be done later. But for now, we have to ensure some space. But I won't be saying the name of the minister, also because I don't know what his name is. No, this is not my cup of tea. I don't want a position in government. I've never been in government. So this is not my cuppa. What I like is to discuss school meals and the council. Oh, now another issue. Just hold on for a second because everybody's asking me how will it work. So actually, we have this intersectorial vision. The working groups are organized like this, which is pretty much how ministries work, health, agriculture, this and that. Now we have the challenge while in this building process to promote dialogue among the working groups because there are some shared issues at IDEC. You know this very well, right? The demands come from all over the place. We cannot do everything right now, but we have to create some mechanisms. The council, Conseil is one of them, is one of the key mechanisms. In some occasions, the Conseil was the most important space for interministerial interaction, and people would call Conseil to know what they could use for foreign policy. So that was the importance of the Conseil's articulation power. And also we have the social, the actors from society. We need to involve them, listen to them. I don't even know what's going to happen tomorrow. Maybe we'll have a lot of people waving flags. Well, luckily, this is a meeting that will be held in Zoom. But the fact is that there's a lot of anxiety. And in 2002, do you remember when Lula won? All social movements got organized, built their agenda, and put it out there. So I think that ideally you should have a good ruler surrounded by good people because this is how you build good government. So now we have to look at the social movements and hope that they get mobilized.
There's a question from Beatriz. Thank you very much, Renato. Are we out of time? I guess we are, right? Okay, so we can have our discussion in our happy hour. Well, everyone, I wanted to thank you once again. I'd like to thank the panelists beside me. It has been a pleasure. I'd like to thank the University of São Paulo once again for the invitation and for allowing me to be here today. And you are all invited to our cocktail next door. But before that, we have some final remarks before we close. My name is Luisa. I'm also part of the research group for the Law and Public Policies group. So on behalf of our group, I would like to thank you all for being here today. I'd like to thank all our partners who allowed us to have this event. So you're all invited to our cocktail. It's going to be at the Visconde de Leopoldo room at this floor of our building, and we can keep on asking questions. So feel free to join us. Thank you very much. And I'm in line to ask a couple of questions. Thank you.